you got charged with one of our most common recent charges, which is driving without insurance. That's a misdemeanor. It's punishable by up to a year in jail and a fine of not less than $200, not more than $500. It requires that you get fingerprinted. They also charge you with failing to report a property damage accident and leaving the scene of a property damage accident. I'm not sure you can be charged with both of those things. Here it is. You talked to the public defender, Ms. Jackson. Apparently he doesn't have his insurance situated yet.
Not at this moment.
Do you plan to get insurance?
I was planning on it, but the vehicle is broken down, and as of right now, I don't have that extra money to be able to.
What kind of car is it?
It's a 2007 Chevy Tahoe.
How many miles on it?
Roughly 270,000.
Well, those mid-teens Tahoes will go a long way. I don't think the new ones will go that far. Well, you're suggesting, Ms. Jackson, we set a pretrial out after the first of the year?
Yes, Your Honor.
Let me tell you some bad news. When you're in an accident and you don't have insurance, you're not covered by the no-fault statute. So you're likely to get sued by the other people's insurance company for thousands of dollars. So that may be in your future. I don't think they can convict you of both leaving the scene and fail to report an accident. I think it has to be either one or the other. But the public defender suggests we adjourn this to let you try to get your insurance and see whether the prosecutor will give you some consideration. What do you do, sir?
I work at an RV factory.
At where?
At Jayco RV factory.
All right, good for you. You appear to have a valid license, so you got that going for you, but people get behind and they can't pay their insurance. They try to dodge between the raindrops, and then sometimes they get wet. I'm gonna set this for a pretrial for January 15, 2026 at 8:30 a.m. That would be a Thursday. Bring proof of insurance or sale of the car. See what you can accomplish in the meantime. Just a minute, let me make sure you don't owe me any money. No, you're good to go. See if you can get your insurance and bring that in January. Are you missing work right now?
I had to leave work to come here.
All right, well, get back to work. I'm sorry to make you miss it, but we can't do the pretrial today. So we'll try again in January.
Okay.
All right, you're good to go, sir.
Thank you.
Edwin Calderon. All right, Mr. George, this is under ordinance. This is 2525050T. Are you Edwin Rodriguez Calderon?
Yeah, that's me.
What does your mother call you?
Edwin.
Edward? I don't know if she call you Ed or Eddie or hey you. You got a ticket for violation of your instructional permit, which generally has to do with driving without a licensed driver in the car. Now, you are eligible for a Michigan license, which is a good thing because some of our people can't get one regardless. Let's see what it says you did. Stop to make a left turn. Driver stated he has a temporary permit, no licensed person in the vehicle with him. Now that happened on allegedly November 29th. It's not that much of a ticket. It carries a fine of up to $100 and up to 90 days in jail. But you don't go to jail for this, but it could undo your ability to try to get your license. Driving in violation of a permit makes it hard to get your permanent license. You may have to wait. Mr. George, did you and Ms. Jackson have any discussion on this?
Sure, we'd offer.
All right. It's so very helpful to have you here. I greatly appreciate it. Let's break that down a little bit. What you're charged with will go on your driving record and it will affect your ability to get your license. You might lose your temporary permit and have to wait 180 days and start all over again. The prosecutors agreed to dismiss that charge for a plea to the very minor misdemeanor of allowing another to violate the motor vehicle code. That doesn't go on your driving record. And it won't affect your ability to get your license when it's time to get your license. Do you understand?
Yeah.
All right. Are you willing to plead to that charge?
Yeah.
All right. I'm going to fine you $200. I'm going to give you time to pay it if you need it. Other than that, did anybody promise you anything to get you to plead to this? Or threaten you?
Nope. No threat.
All right. You may not realize it at this point, but that's a gift from the city attorney. Because if you lose your license, you're going to be on the driving suspended merry-go-round and you won't be able to get off of it. So all you have to do here is pay the fine and not drive without a licensed driver in the car till you get your license. Then you'll be good till you're 85 years old. But you're going to have to pay me $200. Understand?
Yeah.
All right. Were you driving a car that day on November 29th without a licensed driver in the car?
Yeah.
Why is that?
I was going to the store.
You're going to school?
No, a store.
Well, also the person that let you drive could be charged with this offense. So don't do that anymore till you get your license or have a licensed driver in the car with you.
Yeah. Okay.
All right. Anyway, this is a break from the city of Sturgis. I'm glad it was written under Sturgis ordinance, so I had a prosecutor here to help me. It's a $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee. So you're a Sturgis High School student?
No, I recently graduated.
Okay, last June or just now?
Last June.
Okay, what do you do now?
I work at factory.
All right, so you can afford to pay the $200 fine?
Yeah.
All right. Do you need time to pay it or can you pay it today?
Do they take card?
Yeah, but I'll give you until they'll take a card. I'll give you until February 1st. And I'll give you something. There's instructions in here on how to pay it with a card. Costs a little extra.
It's a fee if you use your card, so if you bring cash, it can save some.
All right, let me repeat. Don't undo this. You stay within the restrictions of your restricted license till you get your full license. this isn't gonna ding you up like the charge would have. So don't drive around without a licensed driver in the car. Get your license, parallel park, do all things you need to do, and then you'll be good forever. All right, you owe me $200 by February 1st. You're good to go.
All right, thank you.
Thank you. Good luck, sir.
Yep, you too.
All right, that was a gift from Mr. George. Taya Layton. Good morning.
Good morning.
Let me get into your file here. My ears are plugged up after I sneezed. This is file number 252402, People versus Taya Marie Layton. You got charged with driving without a valid license ever acquired, similar to the other guy, no proof of insurance, and failing to yield. Let's take a look at your ticket. That's not very helpful. This ticket was, God, I don't know. This is another Sturgis ticket in Sturgis by a Sturgis officer that they wrote under state statute. I think Chief Bowling in Three Rivers I sent that letter. They can choose to do it this way, but they're costing the city thousands of dollars through benign neglect. Anyway, Miss Layton, you've got lots of baggage on your driving record.
Mhm.
You're I don't have a driving record in this file. Darn it. Let's see if they put it in one of the other cases. I didn't catch it. Usually I'll ask to put it. Could you put give me a driving record on Taya Layton? I don't have one in here and I should. All right, let's talk about your baggage. In 2018, you got charged with driving suspended. They reduced it to allowing another to violate the motor vehicle code. You did pay the fine on that. 2018, that's not a driving charge. 2020, that's not a driving charge. I thought there was another traffic in there. You also owe me $299 on a disturbing the peace, $290 from 2020. I could put you in jail if you want, and we could wipe that fine out. It's from a disturbing the peace from 2022. I'm having a little trouble because I don't have your driving record in here to help me figure out what the deal is. How'd you get here?
I got a ride.
Where's your ride?
They had to go to Three Rivers anyway.
They dropped you off on the way to Three Rivers?
Mhm.
All right, let's make sure she didn't drive here. What are you doing now, Miss Layton? Are you working somewhere?
I'm trying to find a job right now. It's kind of hard without reliable daycare or anything like that.
Yes, and without a license.
Yeah, everything with their dad. So I don't really have the help at all. And I got denied cash assistance.
All right, they put it in there. So let me see if I can get it. Uh, Well, I'm gonna shut that program down and reopen it. Sorry about that. They say it's in there, but I can't get the program to refresh, so let's try again. Oh, boy. Now, Shayna, I can't even get it to open now. Let me try something different. I can't get it to update and I can't get it to open.
Did you get it?
No,
Yeah, see your computer, see what it's saying to you?
it says,
Are you typing in our case number?
no, I was going to because I couldn't get this to open. There's the file number.
Okay.
There it is.
You got it now?
I do.
I want to make sure it opens for you.
All right, thank you.
Yeah, no problem.
Well, they charge it as no ops ever, not suspended. You have a state ID from Michigan and you've got Indiana problems. Canceled out of state. Is Indiana the other state?
Yeah, so I tried calling Indiana. They said I have to get a receipt from here, from that one that I paid off. Because they said mine over there is suspended from out of state Michigan.
Yeah.
I've tried calling.
So yeah, you're in a catch.
It's
a big circle.
It's a lot.
Out of state, canceled out of state, OLN. I don't know what that means. Your license expired in 2021, so you haven't had a license for 4 years. And you need a license to drive your kids around and that sort of thing?
Yeah, it's kind of been hard getting back on track after being, with their dad and all that. Because I couldn't work or nothing like that. So once we split up, I was working up until just recently September. Now I got the eviction going on. So it's a lot. And I tried maintaining that fine, but once I lost my job, and then I tried getting cash assistance too.
All right, well, we're gonna get back on track with the fine. I can put you in jail and erase it. But I'd rather you paid the fine than went to jail for 4 days.
Yeah.
But we got long memory around here.
I can come in and
Well,
something Friday.
we can adjourn this, but you're gonna have to do some work. You're gonna have to go to Indiana and get that cleared up so you can get a Michigan license. So it isn't gonna just go away on its own. And then you're gonna be stuck, like I told that kid, on the driving suspended merry-go-round, and you won't be able to get off of it. Plus you got no insurance and you fail to yield. When you don't have a license, it's hard to get insurance. Did they tow your car?
No. And then, so I got insurance, and I thought I got it online, and I thought that I paid up that 6 months. So I had gotten an email, and they told me, oh, well, your insurance is running out. And I was like, well, then why did I pay it to $200 and some dollars? It was all through.
Well, generally you can't get insurance unless you have a valid driver's license.
Yeah. So they let me though. They let me
All right,
register my
okay, well,
car.
they charge no proof of insurance, not no insurance. But you need to get your driver's license, and maybe the only thing that will do it is this. Let's take a look at all these old traffic stuff, because you've got a lot of stuff that isn't traffic. Oh, that's not Taya, that's Rebecca Layton. 4. Impeding traffic in 2016, you had a valid license at that time. Drive without due care or caution, 17. 18, allowing an unlicensed driver to drive. That probably started as a driving suspended. Thought she had a permit. So you've been dealing with this since 2018. There's other stuff which doesn't have to do with driving in here. It's this one. Booking fee that you didn't pay, but I'm not worried about that. I don't see that you have any unpaid Michigan traffic tickets.
No, when I got pregnant with my daughter, I paid off that last one that I had here in Michigan. And so that I could try and get my license. But again, I didn't know that I had to get the receipt or anything until this year, because I didn't have to drive while I was with their dad. We just paid that off. So then we paid it off, and then I called Indiana recently before all of this happened to try and get my license back, and they said, well, you have to come over here, get the receipt, then you gotta go to the bank.
All right, well, you're here. We can get your receipt right now.
So
I'm gonna set a pretrial out for a ways. I'm gonna set it for February 5th. All right, you need.
Count 2 is an F5. We're just missing count 1, which is an F4.
Is that accurate? Yes, sir. All right, Mr. Rhodes, they're telling me you're going to change your plea to 2 counts from the indictment. Before we get to your change of plea, I am required to go over some things with you. Okay, sir?
Okay.
How old are you?
61.
How far did you go in school?
I went 4 years. So, well, post high school. I went to Hillsdale
Are you
College.
able to read and write?
Yes,
Are you a citizen of the United States?
I am.
Has anyone promised you how the court would sentence you in this case other than what I explained to Mr. Madden? That for this case, at least, we have another case that's pending that you have a probation violation on, that I intend to send you to prison on those cases. And this case, you'll receive 12 months in prison to be run concurrent with that case. Other than that, has anybody promised you anything?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation that you received from Mr. Madden?
Yes.
Are you under the influence of any drugs or alcohol?
No.
I have in front of me a document called a change of plea. On the second page on the line marked defendant, there is a signature. Did you sign this?
Yes.
Did you read this and go over it with your attorney?
Yes.
And you believe you understand what it says?
Yes.
This document says running a plea of guilty to 1 count of receiving stolen property as a felony of the 5th degree that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The second count is one of driving under suspension, a misdemeanor of the 1st degree. That carries with it a maximum sentence of 180 days in the Warren County Jail, a $1,000 fine, and does carry with it a mandatory 3 days in the Warren County Jail. Do you understand the maximum penalties?
Yes.
You're also, on this case, subject to a discretionary period of post-release control, which means upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes.
You are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
I do.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
I do.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes.
Do you believe you understand each of these rights we've discussed?
I do.
You understand that when you enter a plea of guilty, you'll be waiving all these rights. We will not have a trial.
I understand.
This is how you wish to proceed.
Yes.
Ms. Nicholson.
Your Honor, if this would have proceeded to trial, the state would have proven beyond a reasonable doubt that on or about November 3rd in November of 2025, the defendant used his father's credit card, which he was not permitted to do. He was given the credit card for use only in emergency circumstances. He used it beyond the scope. Additionally, he was found to be driving his vehicle while under an OVI suspension in Washington Township, Warren County, Ohio.
Mr. Madden, anything on those facts?
Nothing on
Mr. Rhodes, did you hear the statement that she read?
Yes.
Do you admit and acknowledge that what she said is true?
I do.
And again, you understand all the rights you're giving up by entering a plea of guilty, those rights we discussed.
Yes.
What is your plea?
Guilty.
Court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court accepts your plea of guilty. Based upon the statement of facts in your plea, the court will make a finding of guilty. It's my intention to proceed with sentencing. Anything on behalf of the state?
No, Your Honor, there is no restitution requested. We have nothing additional to what was discussed in chambers.
All right, Mr. Madden, anything?
No, Your Honor.
All right, Mr. Rhodes, is there anything you want to say?
Just that I think there's been some confusion about implied alcoholism. I am an alcoholic. And if I've misled somebody to believe otherwise, that is not my intent. But after my sentencing is, or after my obligations are met, in terms of my prison sentence, I do intend to get help with my alcoholism.
All right. Well, we've tried to offer you help, Mr. Rhodes, and it doesn't seem to be taking. And one of the issues is that when you go in for an assessment, you diminish your abuse of alcohol to the person that's making the assessment. That seems to be the problem. I think we all believe that you have a problem, and that's why we we get the assessment done. But then when you are assessed, you seem to want to diminish the alcohol use. But that's okay. With regard to case number 25CR42353, Mr. Madden, does your client wish to have a hearing on that probation violation? Because I intend to do it all at once.
No, Your Honor.
All right, Mr. Rhodes, you understand you are entitled to have a hearing on that probation violation allegation.
I understand.
You wish to waive that and admit to the violation.
Let's just get it all done.
All right, anything else you want to tell me?
No.
Okay, then on case number 25CR42353, the court's going to order you to serve 12 months in prison on the failure to comply, 12 months in prison on the operating a vehicle while impaired. By law, those are required to be served consecutive to each other for a total of 24 months. On the aggravated menacing, 180 days in the Warren County Jail, that to be served concurrent. You have 256 days jail time credit towards that sentence. The court does find and has found that you're indigent. There is a $1,350 fine on that case that I do not have the authority to waive. And again, the court has already ordered a lifetime operator's license suspension effective April 22nd, 2025. And under case number 43157, the court's going to order you to serve 12 months in prison. That to be served concurrent with case number 42353. And again, 0 days jail time credit on that case. Court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Now, you're also...
There is a $250 mandatory minimum fine on count 3.
Of this case?
Yes, the driving under.
Oh, the driving under suspension. Yeah, I forgot about that one. The courts will order you to serve 180 days in the Warren County Jail on count 3, the driving under suspension. By law, that to be served concurrent. What was the mandatory fine?
$250.
All right, there is a fine, again, a mandatory fine of $250 that the court does not have the authority to waive on that. I apologize for not disclosing. Does that make any difference with regard to your plea?
No.
All right. And that's because it was under an OVI suspension. That's why it's a mandatory fine. Okay. Now, you're also subject on these cases to the discretionary post-release control. Do you want me to go over that with you again?
No, that's not necessary.
All right. There may be opportunities for you to receive up to 1 day per month for participating in certain education, vocation, or other programs sponsored by the Department of Corrections. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Nicholson, did I leave anything else out?
No, Your Honor.
Mr. Madden?
In the 3 days mandatory time on the count 3, that's melded into the 180 days that you gave me.
Yes, yes. In fact, I think he's already served that, so. All right, good luck to you, Mr.
Thank
Rhodes.
that people would waive any conflict between this honorable court and the office of public defender. And people do not believe that any conflict exists. We make a waiver for the avoidance of all doubt.
Good morning. Well, the defender's office likewise does not believe the conflict exists, but if one does, we also think.
Thank you. The court for its part also does not believe there's a conflict either under Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Brianna Jones.
Ashley Phelps for the people.
Who was that? Was that you?
That was the whole other side of the court.
That was you?
Why am I the first one you asked?
Was that what? You, because you reached in your pocket.
Okay. And assistant.
And since it's not you, I would have yelled uncontrollably.
Oh, I would have just looked down. I would not have even looked up.
Yeah, that's probably true. It's okay, ma'am. Just please turn off your alarm. Okay?
And Assistant Public Defender Natalie Pate with and on behalf of Miss Brianna Jones, who appears via Zoom from the MDOC. Ma'am, can you please unmute, state your name for the court?
Ms. Jones, do you hear us?
Yes. Yes, I
Okay, can you state your name, please?
Brianna Jones.
Thank you. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading guilty to the charge of assault and or assault and battery, the 93-day offense. Upon her successful plea to that charge count, one would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
That is our full understanding, Your Honor. And prior to the plea, the only thing I want to add, I do understand it's a victim rights crime, but my client is asking if the court would just, after the plea, set it for sentencing as soon as possible, the next possible date.
Ma'am, can you please raise your right hand?
Yes.
Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes.
State your name again for the record.
Brianna Jones.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of assault and or assault and battery. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
Understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You had signed or caused to have signed an advice of rights form. Is that correct?
Yes.
You went through that with your attorney?
Yes, I did.
Or did you? Okay. Any questions you have regarding any of those rights?
No.
You understand that you're waiving or giving up the rights that are contained on that form?
Yes, I do.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole? You're not. Is that correct? All right. Has anybody promised you? All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, they haven't.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily
Yes.
of your own free will,
Yes.
and also because you believe that you are indeed guilty of this offense?
Yes, I am.
I have a problem here on my end, but we'll deal with it. On the date of June 20th, 2021, at the location of the Huron Valley Correctional Facility, Pittsfield Township, Washington County, State of Michigan, what did you do regarding a Ray Lynn Dennis that makes you think that you're guilty?
Well, it was a mutual fight, and then I continued to fight back.
Okay, so there was a fight. The fight stopped, but then you continued with the assault. Is that correct?
Yes.
All right. And you didn't have that individual's permission after the initial altercation to continue that fight or to strike or hit them. Is that correct?
No, that's right.
And That is correct, okay. And you did that intentionally, correct, ma'am?
Yes.
All right. Ma'am, I do have to advise you that if you commit any type of misconduct as defined by the Michigan court rules between the time that I accept your plea and the time of sentencing, that you would not be entitled to withdraw your plea and you would not be entitled to any sentence evaluation or recommendation. You understand that?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rules?
People are satisfied.
Yes.
Court will accept the defendant's plea of guilty to this charge. It's 17. Pre-sentence investigation and report is ordered through probation. Sentencing in this matter, we have to, and in terms of date, ma'am, I have to at least give 2 weeks for the video writ, but the earliest that I can set is January 14th, 2026, 9 a.m. All right?
Okay.
All right, bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Ms. Jones.
Court
Thank
calls
you.
case of Courthouse case, People versus Sharon Abbott.
Ashley Phelps for the people.
Morning, Your Honor. Sam Bernstein with and on behalf of Ms. Abbott.
Hello, what's your name?
Morning, Sharon Abbott.
All right, what are we doing?
You're in arresting for an adjournment. This is a case where Ms. Foster Tucker is speaking with the prosecution about a resolution.
I think we're gonna get there very soon, Your Honor.
All right. So the next day,
January 7th.
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 So we'll be adjourned January 7th, 2026, 9 a.m. Bond will continue.
Your Honor.
Court calls case of the People versus Rick Artuso.
Ashley Phelps for the people.
Morning, Your Honor. Police Honorable Court, David Burgess on behalf of Rick Artuso. Your Honor, I'm not sure if he's on, he did call the court, I guess, this morning. He's having truck problems. I spoke with Ms. Feltus. Judge, we're going to draft a stip and order. He's on probation to Judge Conlon, and we're going to add the restitution requirements to that order of probation. And I believe the people are going to be dismissing the misdemeanors in this case. Well, once we do that and have it entered.
That's correct, Your Honor. So he only has to do one probation.
Got it.
He's been here a lot. Wasn't coming for quite some time. I don't have a problem adjourning today without him being present if the court would allow it, just so he doesn't get a warrant.
I don't have him.
He's not getting Zoom, but I can.
He did.
He did.
I'll adjourn this. Will January 7th would be my,
I'm here, Judge, I believe anyway.
That's fine, thank you.
adjourn it January 7th,
All right, no,
2026, 9 a.m.
I'll let my client know. Thank you, Your Honor.
All right. Court calls case of the People versus Julina Azir.
Focus for the people.
Coverall on behalf
Oh,
of
lady. Go ahead.
Sorry.
Covered on behalf of Mrs. Zier, who stands before you with her phone silenced. Mrs. Zier, please state your name for the record.
Jelena Azir.
Thank you. Thank you. Your Honor, I was appointed very recently, so we're asking for a brief adjournment at this time.
Adjourn the matter to January 7th, 2026,
Thank you, Judge.
9 a.m. Thank you, ma'am. Bond continues.
Thank you, Your Honor.
Come talk to us.
Court calls case People versus Zeke Church.
Ashley Phelps for the people.
Your Honor, good morning to you and the staff. Vincent Haysha appearing with and on behalf of Zeke Church, who's present through Zoom with no objection.
Is it just Zeke? Okay.
Yes.
State your name.
Zeke Church.
All right. Has there been an arraignment on this?
No, Judge, as to the arraignment, I'd waive formal reading and stand in mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea.
Thank you, Judge.
Thank you.
As to the pretrial, I've received written discovery. We followed up. We're looking for electronic discovery. I did also email Ms. Landy about a proposed resolution. That in mind, asking for another date. If the 7th works for the court, that would work for me. I'll make an appropriate Zoom request.
I'll adjourn the matter to January 7th, 2026, 9 a.m., or as your invite indicates. As to defendant's bond, I will set his bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possession of any weapons or anything fashioned to be a weapon. there's to be no use of any alcohol, recreational marijuana, or any illegal drugs. I will also indicate that is there any reason you need to have contact with the victim in this case?
No, Your Honor, they don't know each other, and I'm not sure he would recognize him if you walked right into the room with him right now.
All right, and is there any reason you need to go? What is the 4095 address?
That is the incident location. I have another person as well as 2 other locations. I'm requesting no contact with the person.
Okay.
Go to.
Hang on a second, let me get this one. Then
Sounds great.
I'm gonna order no contact with Xander. I think it's Schrader.
I think so.
Okay. And who are the others?
The second person will be Cara Christine. Cara spelled with a K, K-A-R-A, Christine, K-R-I-S-T-I-N-E.
I-N-E, okay.
No objection.
And the no-go to would be that 4095 Carpenter Road location in Ypsilanti.
Okay.
416 West Coruna Avenue, C-O-R-U-N-N, both is in Nancy A. Which is also in Corona, Michigan.
In Corona, Michigan.
Yes, Your Honor. And then the last location that people would request a no-go to is 4600 Britton Road.
4600 Britton.
Lot 203 in Perry, Michigan. Those are those people's addresses, Your Honor.
Got it.
Of course, no objection.
And what are the numbers with the Corona address?
416 West Corona Avenue.
Just 416?
Yeah, West Corona Avenue.
West.
Don't have a zip code. I can find one.
No, that's fine. So, sir, I'm going to indicate that you are not to go to those specified addresses. You understand that?
Yes.
And there are the 3 of them that have been stated on the record. And you're not to have any contact with Xander Schrader or Christina or Cara Christine.
Understood.
All right. Anything further on this?
No, Your Honor.
All right. Thank you.
Thank you, Judge.
Court does call the case, People versus Caleb Kashan.
Ashley felt this for the people.
David I. Goldstein, appearing on behalf of the defendant.
Your name?
Khalid Kasham.
Khalid. Gonna mispronounce everybody.
It's spelled like Caleb. Inside of your pockets.
What are we doing?
A final settlement conference room. I understand it's in February and I'm going to be gone the month of February.
Your what?
I understand that your next date is in February.
Yeah.
And I'm going to be gone the month of February.
The whole month?
Yes.
What up with you? I mean, no, I guess I shouldn't have said it.
Judge, when you're my age, it takes a while to recharge your batteries.
Okay, the whole month. Okay. Then our next dates are in April. So jury final settlement conference on this. Is there any objection from the people to that?
Yeah.
All right. Will be set for April 10th, 2026, 9 a.m. Jury selection, if necessary, would be April 13th.
Yes.
April 13th, 2026 at 8:30. Both of those proceedings are in person. Bond will continue with its conditions.
Thank you, Your Honor.
Thank you. The court does call the case, People versus Shante Wingard.
Ashley felt this for the people.
David I. Goldstein, appearing on behalf of the defendant. She's approaching, Your Honor.
Hello,
Hello, your name?
Shantae Wingard.
Thank you.
Same situation in this matter, Your Honor. Final settlement conference.
Jury final settlement conference, April 10th, 2026, 9 a.m. Jury selection, if necessary, April 13th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you, Your Honor.
Continue. Thank you.
Process.
Yeah. Yeah, okay. Court does call the case of the people versus Jamonte Love.
Ashley Feltus for the people.
Good morning, Your Honor. Shauna Basti appearing on behalf of Jamonte Love. Mr. Love, state your name for the record.
Jamonte Love.
Thank you. What are we doing?
We're just having a brief adjournment, Your Honor.
You need a brief adjournment? All right. Adjourn the matter to January 7th, 2026, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Megan Maxon.
Ashley Feltus for the people.
Good morning, Your Honor. Michael Vincent on behalf of Megan Maxon. Please put your name on the record.
I'm Megan Maxon.
Thank you.
Today, my understanding is arraignment and pretrial.
It is, sir.
She stands mute to the charges.
Defendant having waived from a reading, standing mute. Court will enter a not guilty plea on her behalf. And you'd like this adjourned? Or,
Yes.
all right. Will the 7th work, or you need to check your phone that went off? Okay, no,
But it is silent.
it is, okay,
It is.
all right. I still think it was her.
The reason you did is for cause too. That's why you picked
That's
it.
it, exactly. The 7th, okay. I'll adjourn the matter then to January 7th, 2026, 9 a.m. Or as your invite indicates, I will set the defendant's bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons or ammunition. I will also order there to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. Further indicate that the defendant is not to go to any Walmart location in the state of Michigan. You understand that?
Yes. Marijuana.
Recreational.
All right.
You understand, it does have a marijuana medical card.
So that makes it not
Not
recreational.
recreational. I tried to explain.
Yeah, thank you.
And Your Honor, would you be able to have that order, no going to Walmart effect on my wife?
No.
Okay,
No,
I'm just
so,
asking.
you know, you were trying to do that. Garen was trying to do Costco. I'm not doing it. Both of your wives who I've met are wonderful, wonderful people. And I think they're certainly are permitted to do anything they want. And if they are spending all the money in the household, I think they're entitled. So,
well, thank you.
You're welcome.
Thank you.
Okay, I will. Thank you.
Court does call the case, people versus Albert Wilson.
Feltus for the people.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Mr. Wilson. We both appear via Zoom. Thank you for that and consent to it. Albert, please unmute yourself and state your name for the court.
Mr. Wilson, can you unmute yourself and state your name, please, sir? You're still muted, sir.
All right. My name is Albert George Wilson.
All right. Thank you. All right. As to the arraignment, Mr. Amadeo.
Your Honor, will waive a formal reading, stand mute, ask for standard conditions. He is 77 and not driving, Judge.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Are you asking for the adjournment of this?
Yes, please, Judge. I'm just waiting on a couple more pieces of evidence. If we could have the Jan 7th date, please.
Adjourn this matter to January 7th, 2026, 9 a.m. As to bond alleged VAC.
0.124. No crash. There is a prior from 2022.
All right.
People would request Soberlink, Your Honor.
Judge, I can briefly respond to that. He's not driving at all. I understand the request for the Soberlink. He's not driving at all. He's basically bedridden, and he does not have any goal to drive whatsoever. So the Soberlink on his car would be kind of overkill. He's basically in his house all the time, not driving any vehicles.
Okay, I understand what you're saying, but I would have no way of knowing that unless I tether him to his house, that he's not doing any of that. But what I'm going to do is I'll set his bond in this case, $15,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior, possession of any weapons. I will indicate he is not to possess and or consume any alcohol, recreational marijuana, or any illegal drugs. I will sign a community corrections order. I will place him on a sober link testing device. So he'll need to get himself to community corrections for that device.
Yes, sir.
Thank you.
Thanks, Judge.
Court does call the case of the people versus, is it Marta Alcala? Having an issue.
Good morning, Assistant Public Defender Lauren Kearney, on behalf of Mr. Al-Khalaf. Say your name, sir. Gonna miss a license. Mr. Al-Khalaf indicated to me that he went to the Secretary of State and they informed him that he had a valid license.
That he had one?
Yes.
He does.
Dismiss.
Any objection?
No objection.
You want your case dismissed?
Yes, sir.
Oh,
How, are you okay?
Yes, Your Honor, he has a new case, driving suspended.
Here?
Yes, it's scheduled for arraignment, township case, 11426.
it was an warrant status. He filled out the warrant recall form. I don't know.
Oh, man.
The date.
So what was the, can you see the offense date on that?
I'm looking on, looks like September 20th.
September 20th, and this was August 29th, so this is all around the same.
But I thought it would be, well, let me see when he was arraigned.
He was arraigned
He was arraigned.
after the fact.
I'll still move to dismiss, Your Honor, but he does have another case coming.
All right.
And because he has a valid license, we'll resolve that one.
Okay. And just keep a license, will you? You just, what I'll do, then this case is dismissed. That, so you got rid of that one. If that warrant was recalled, the case was reset, right?
Right, he was never arraigned on it. It was just out there.
That out there.
So. Mr.
Okay.
Rose let me know that it was pending and.
I will tell you that because Mr. Siller's going to be here this afternoon, if you let Mr. Siller, I'll have the file and can get your client back. I would have the file brought in if it can be resolved and just try to get him done and out of the way.
Okay, yeah, I think we can, and the court knows it's the standard offer on those cases, so.
Yeah, and so if that's going to be a standard offer on it, then if your client can come back, then we can get that taken care of, so he doesn't have to come back in January.
I'm gonna give you a call, Mr. Alcalip, okay? So just expect a call or a text, okay?
Sounds good.
Are you a good driver?
Yes, sir. Hope so.
Sure? Yeah, I hope
Yeah,
so too. Because if I do this for you, you better not come back here. All right.
Don't plan on it.
Okay. Well, we may see you this afternoon then or later on. All right. Thank you,
All
sir.
right, thank you.
Court calls the case, People versus Jeffrey Ostermiller.
For the people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Ostermiller. Mr. Ostermiller, say your name, please.
There he is.
Jeffrey Ostermiller?
Thank you.
Your Honor, Ms. Karen and I had a chance to discuss this case. I understand Mr. Ostermiller is now on probation to 15. So at this time, people are going to be moving to dismiss this case. He can do his probation to 15.
Okay, so he's in 15, so you're gonna dismiss this one.
Yes, sir.
No objection.
Case is dismissed.
Thank you.
All right. Thank you, Mr. Ostermiller. Good luck to you.
Thank
Bye,
you.
you two.
Have a good day,
Court calls the case, People versus Candace Brooks.
Ashley Feltus for the.
Good morning, Assistant Public Defender Lauren Penny on behalf of Ms. Brooks. Ms. Brooks, please state your name for the record.
Good morning, Your Honor, Candace Brooks.
Thank you. What are we doing? I have a plea form. Is that what we're doing?
Yes, Your Honor.
Yes.
Plea form indicates that the defendant will be pleading to retail fraud third degree. Retail fraud second degree would be dismissed. That's count one. So she's pleading count two. Count one would be dismissed.
Yes, Your Honor.
That is correct, yes.
All right. Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, state your name again for the record.
Candace Brooks.
All right, you can put your hand down. Ma'am, it is this court's understanding that you're going to plead no contest to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, ma'am?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. Two things about a no contest plea I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, I do. Your Honor.
All right. The other thing that you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes, I do. Your Honor.
All right. Basis for the no contest plea.
Potential civil liability.
So, ma'am, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, I do. Your Honor.
You signed or caused to have signed an advice of rights form?
Yes, I did.
Any question regarding any of those rights?
No, Your Honor.
You understand that you're waiving or giving up all the rights that are contained on that form?
Yes, I do, Your Honor.
You understand that you're giving up your right to appeal upright?
Yes, I do, Your Honor.
All right. Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, they have not.
Anybody threaten you or coerce you?
No, they haven't.
You're doing this voluntarily and of your own free will?
Yes, I am.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 237707. Any objection to the court reviewing that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I would have to advise you that if you commit misconduct between the time that I accept your plea and the time of your sentencing, that you would not be permitted to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, I do, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
People are not.
No.
And have I complied with the court?
People are satisfied.
Satisfied, Your Honor.
All right, court will accept the defendant's plea of no contest to count two. Count one is dismissed. Defendant is referred to probation, pre-sentence investigation and report. Sentencing in this matter will be January 14th, 2026, 9 a.m. or as your invite indicates. All right, ma'am?
Okay.
Bond will continue. I need you to wait on the line. We're going to put you into a breakout room with probation intake.
Okay.
Okay? And so we can get the sentencing process started. Thank you.
Okay, thank you.
Court calls case, People versus Jocelyn Corona.
Ashley Feltus for the.
Good morning, this is Public Attorney on behalf of Ms. Kawana. Ms. Kawana, please state your name.
We have her,
Not checked.
not checked in.
Yeah, I did speak with her this week. She was going to, portion of a plea form. I did speak with her yesterday and she indicated she's really ill. I don't know if that's the reason. She said she had the flu or something. She was obviously planning on being here as we had planned.
Any objection to an adjournment?
I don't think we have any bond violations, so I will not object to one adjournment.
All right. I'll adjourn the matter January 7th, 2026, 9 a.m. All right, thank you. Mr. Jeff Ostermiller? We already dealt with it, right? Yes. Is there something else?
No, I can.
Were you waiting on something else, sir? Or were you just hanging out?
No, I just hanging out. I can leave.
All right, not a problem. Not a problem. I just want to make sure you all taken care of. Court does call the
Thank you, Your Honor.
cases of the people versus Devontae Connor Belcher.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Connor Belcher. Sir, can you please unmute and state your name for the court?
Devontae Connor Belcher.
Thank you, Your Honor. I'm requesting an adjournment. I found out on Monday that Mr. Connor Belcher does have, I don't think the offense date is new, but some cases he still has yet to be arraigned
I'm in there,
on.
boss.
He contacted the court on Monday to do the bench warrant recalls, but I do not believe those arraignments have yet been scheduled. Two of them are misdemeanor cases that will be coming to this court. So I'm asking for an adjournment of these files to see if we can resolve all four.
I have 3 that are outstanding.
Yes, 3, and one's a felony, I believe.
Yeah, none of the 3 I have are felonies. They're all retail fraud seconds.
Okay, Your Honor. Yes, I think it was out of the 15th district court, there was a felony case, but he still needs to be arraigned on that. So that being said, I was requesting adjournment of the pretrials and
I'll adjourn the pretrials in this matter January 7th, 2026, 9 a.m. He needs to get all of these other matters taken care of, or at least set for hearing.
yes, Your Honor.
7th, yes, January 7th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you, Mr. Belcher. I'll be in touch.
Yeah.
Courthouse case, People versus Daniel Worth.
What was the last name, Your Honor?
Got it.
Ashley Phelps for the people.
Daniel Worth.
And this is why you left. It was not what they told you it was, and it was too restrictive. I mean, you don't show up, you leave, and then you test positive not only for cocaine, but you test positive for fentanyl and norfentanyl. And you probably took a drug, you probably may not have even known that the fentanyl or norfentanyl were even in the substance, which is even more scary because it will kill you. So request for bond modification is denied. You will be held in the Warren County Jail. I'm not going to take a chance on you dying, quite frankly. At least in the jail, I know I'm not naive. I'm not so naive to think there are no drugs in the jail, but it's going to be much harder for you to get. So at this point in time, you will be held in the Warren County Jail. Anything else?
No, Your Honor, thank you.
All right, thank you all.
No, Your Honor, thank you. Do you want to think about it?
Yeah, but I didn't have to tell nobody. I didn't.
Defendant is not here. Doesn't have counsel. Ben,
It's a worth with an I. Thank you so much, Ann.
Ben, what'd you say?
I thought you said worth, like value. So I was thinking.
Oh,
I'm trying to find
yes,
the
it's
space.
RWI.
Thank you. Your Honor.
All right.
I was thinking worth value too.
Oh, okay. The 14B case numbers. Oh, got it.
Yes. Okay. Bench warrant will issue for defendant's failure to appear. And the reason I had the case is because of disqualification. It was reassigned to me. Bench warrant will be set in the amount of $10,000. I will give a 10% privilege on that. That warrant will issue immediately.
Is that case number 25S00429SM?
Yes.
Thank you, Your Honor.
Ready for that block?
Thank you, sir.
Basically right on time, despite pairing me.
What did I do?
You just don't even know now. All right, court's gonna stand in recess. We'll get set up for the next block. I'll be up. Oh. Over there. Over there, that screen.
Yeah.
But women sent to the court a report dated December 6, 2025. Have you had a chance to review it and state? Yes, Your Honor. It will be marked as Court's Exhibit 1 on this day. We found Dr. Lacan has determined that the defendant is not competent at this time to proceed with the resolution of her legal issues. And the doctor deems that further medicalization is necessary as she is diagnosed with a schizoaffective disorder. And it's not on medication and it's being untreated and it needs treatment. So that shall be done. And in her current medical state, according to Dr. Lacan, it would be reasonably psychiatric probability that she is unlikely to be able to communicate with her attorney with a reasonable degree of rational understanding and be able to help prepare her defense. So she requires inpatient treatment of a psychiatric nature for restoration of competency. This Court's Exhibit 1 will be a part of the record and will be placed in the file. And an order with those findings will be prepared. Anything to add from the defense or the state? No, Your Honor. Okay, and we'll reset this for a review in several months.
Yeah, I think the initial's under 20 days, Judge.
Taylor Neville.
My understanding is.
Where's Taylor Neville?
Out in the hall.
All right, we need him, please.
Sir.
Oh,
Mr. Wilkerson. Sorry, Mr. Wilkerson's followed notice of representation.
25 CR 1417. Tyler Neville.
Yes, I believe there was a letter of representation filed by Marcus yesterday.
But he's not here, right?
I don't believe so.
I haven't seen him, but was told he followed.
Sometimes yesterday is right.
Are you Taylor Neville? And you were charged here with the state jail felony of injury to a disabled individual, which carries with it up to 2 years in the state jail. Mr. Dusler was appointed to represent you. Have you actually hired?
Yes, I hired Marcus Wilkerson.
Hold on. I'll speak. I'll end my sentence and then you can speak. Don't interrupt, okay?
Yes, sir.
Have you hired Mr. Wilkerson to be retained as your attorney?
Yes, sir.
All right. Then he's not here though, right? Okay. All right, what we're going to do is set this for an announcement and we'll get the message over to him, but it will be an announcement. What's the thing?
6 weeks.
6 weeks. Get a resetting. Willie Q. That lady.
He's in custody and it's not been brought back yet. As soon as he gets here, I'll talk to him.
Ronald Tyler. That's you. And
One right there.
have you talked to your attorney? He's around today. Is Mr. Gertz here?
I have a team today, goes back and text.
Okay, Mr. Ham, this is, we're gonna try to find him. We need him here before we can do anything. This is a plea hearing. Is this gonna be disposed?
This is that case that we've gone back. This is the case that we've gone back and forth with Ryan. It was specially set and we had to share them next door. And we've been putting the pressure on to get it resolved. He announced it was going to be a plea. I've got one of the kids here.
Okay, yeah, we need him
to be done
here on Mr. Tyler's cases. I've got three cases pending. All right, okay. Let's, we're going to try to call Mr. Gertz, find out where he is. Mr. Johnson, Charles?
Sure.
There you go. On Dion, show me. Good morning. Well, welcome.
Mr. Shoemate. Mr. Shoemate on his way out.
Where? Just one case.
Yes, sir. Your Honor, Mr. Shoemate is currently.
Well, this is 24 CR 901 and you were Dion Showman.
Yes, sir.
Okay, with your attorney, Mr. Johnson, and the state's attorney. Go ahead.
Judge, Mr. Shoemate is currently in a residential facility run by the Veterans Administration Rehabilitation. They get permission to come here to court today. I'm spoken with the state and I'm going to be applying for their Veterans Court program. I think he's an excellent candidate. He has no history besides this. And I think he'd be an excellent candidate.
Why is this taking so long? I mean, we've been dealing with this for a year and a half now.
I haven't been on the case. That's all I've done.
Yes, yeah, back in May is when you were arraigned of 2024. And then somebody was appointed to represent you. It looks like Langston Adams, maybe, back in June of 24. Man, that's a year and a half, and we hadn't gotten a darn thing done. Well, that's not right on my watch. That's not. We moved forward. How long is this going to take? Not another year and a half.
No, not at all. As I said, he's currently in residential with the Veterans Administration, and I'm pretty sure that the state can make a decision about their veterans program pretty quickly.
We'll just have to turn over the paperwork and have it reviewed by who runs the Veterans Court in our office.
I'm going to reset it for how long, do you think? What do y'all think? I don't know what y'all's timetables.
4 weeks.
4 weeks, okay. All right, let's see what we can do about it, huh? Yes, you've got with Colby, Washington too, right?
I do.
How many? 4 cases?
Yes.
What are we doing? Where's Mr. Washington? Come on up. You're the guest of honor here.
Yes, sir.
Yeah. Yes, sir.
Okay. This is going to be, who's the state's attorney on this? Mr. Ham? You are with Colby, Washington. You got 2 second-degree felonies of sexual assault of a child. That's up to 20 years on each case. Second-degree felony of online solicitation, that's another up to 20 years. And illegal possession of child pornography up to 10 years. Hello. We're talking about you're exposed to up to 70 years in prison on all of this. Serious, 4 serious cases. All right. Today, what are we going to do?
Your Honor, I have speaking to the state, conveying an offer of Mr. Washington indicated that he does not wish to take their offer.
All right, set it for trial. Which case do you want to go on first?
I don't want to make that decision today, Judge.
Okay. We got 4 of these, and we'll just do them one at a time. I guess one of the second-degree felonies.
Yeah, and I may try all of them together. I do intend to file a motion to consolidate. That's why I'm not prepared to make a decision about which one I'm moving forward on first.
The state has made
All right, we'll send it for trial. When can y'all be ready? Because these are fast tracked when they're involving.
I'll work as diligently as I need to, Judge.
Yeah. Okay, it's going to get fast tracked. Y'all just get ready.
Yes, sir.
And we'll try these as soon as possible. I have Terrence Killian's work. Yes, sir.
Sorry, down yet.
All right, it's you're Mr. Killingsworth here, 242159, a state jail felony up there. What are we doing?
On the first.
What are we doing?
On the first.
I'll set it for trial.
Well, I think-
We gotta move forward. I got a trial to get into.
Just, I
Y'all just standing around and.
think he had other cases pending for indictment, and second. So, that correct?
Australian?
It is my understanding that there are another case or other cases coming, Judge, but it's also my understanding that defendants going to want a trial on these anyway. So we can put it on the trial docket.
That's.
All of these are set for trial. What's it said for? You're not surprised. Perez.
Perez.
That's you, sir? You're Mr. Perez speaking. You're Shar. No, what are we doing? Just, it's an amendment. You can just tell me. Willie Thomas. This is What are we doing on this one? All right. When can y'all be ready on this first degree felony of aggravated robbery? That's what we're gonna try first.
Yes, sir. A couple weeks, I can be ready, 2 or 3 weeks.
Okay. So we're gonna go to trial. Put this on our trial in 4 weeks, please. Thank you. Charles Dumas.
Thank you. No,
Charles Dumas. Charles Dumas. There is no answer in the courtroom. I ask the bailiff to call into the hall for Charles Dumas. 2 cases, 24 CR 805 19-31784. Always Dumas. We keep it out.
Represented by Ms. Kirby. We have Mr. Goodyear from the prosecutor's office. We are here today for a pretrial. It's my understanding we're going to set this case for another pretrial in January, but that the defense wanted to be heard on the issue of bail, right?
Yes, Your Honor. Thank you. After discussion with Mr. Isaacs and his family, who is all here in support of him today, we request that bond be modified to cash, surety, or 10%, any of which the court would allow. The family has explored the idea of a surety bond and would like to explore that further if the court would allow that. Mr. Isaacs is not a flight risk. He will show up to court, and the court has no, should not be worried that he will be on the run pending further hearings.
So Goodyear, the position of the state and or the victim on the request?
I've spoken with the victim about this situation a number of occasions, and she would be opposed and we would be opposed on her behalf. And also because I think that the reason the bond was set, I think all the reasons that existed have not changed. There's been no change in circumstance here. I think the bond was appropriate. And I think the court should maintain the bond. Thank you.
Anything you want to tell me on that limited issue, Mr. Isaacs?
Yeah, I have a 6-month-old baby. I'm just trying to get home. My dad's 77. I'm not in a flight risk. I'm 50 years old. I turned 49 today. I'm done with drugs. I'm finally starting to get things together. I've literally finally got myself on track. It started in 2021, and I've been out of trouble. I haven't been in trouble. So, Your Honor, I just want to be with my family for the holidays. I want to be with my baby. She's here in the courtroom. She's little. She needs her dad.
One of the things you said, Ms. Kirby, I mean, his bond is $100,000 cash or surety right now.
No.
Your Honor, we were requesting that the bond be lowered so that way the surety was more of a attainable number.
Okay. But I mean, his bond right now is $100,000 cash or surety.
Yes, Your Honor.
There is no 10% on it right now.
Correct. Yes.
All right. I'm not going to modify the terms of your bond today, Mr. Isaacs. But go ahead and file a motion, and we will also address this when we come back for the pretrial in January, but I'm not going to modify it today.
So it is cash or surety, though.
It is cash or surety. I mean, it's also, there's an EM requirement, but I'm looking at the arraignment entry right now. I guess I should look at the bail order too, but.
Because the bondsman said that there was no cash or
I mean, there's no such thing as a cash-only bond in Ohio anymore. They did away with those a while ago.
Oh, I didn't know that.
So generally speaking, this means if you put up 10 grand to a bondsman, then you can get out. You don't get it back, but it's not property and it's not 10%. Okay? All right. See Ms. Otto, get a date.
All right.
Thank you, Judge.
Are you Charles Dumas? Scott Rennick is your attorney? Where is he? Well, yeah, well, it's.
You can leave that up there.
Who's the state? The state's attorney is on this one is Sue, Charles Dumas. That's mine. Yeah, we're going to do this motion to revoke unadjudicated probation. We're going to get this as quick as we can.
Yes, sir.
Yeah, they've got a new indictment on the criminal mischief, which is
Yes, sir. That's
the allegation.
Judge, the deal on that is he's paying restitution. We've already worked out a deal with Mr. Rennick. He's paying restitution. This was a company truck. So
Mr. Rennick's not here.
we're going to dismiss the new case if he pays restitution. And he's been working on, he's already paid half of it, and he's got another half to pay. And we were just going to do this week to kind of check up and see where he was on gathering the money.
Okay. All right. So
this will go away.
We need to wait on Scott Rennick to get here as attorney, or can we just reset this?
We just need to reset it because he's still gathering money.
When?
Probably another 6 weeks, kind of see where he's at with the
I
money.
don't know. Where are you on it? On the money?
Yeah.
So well, how much money is it? Would you have to pay?
He paid 12,000. He owes 8,000 more.
You have 8,000?
Yes, sir.
You paid 12?
Yes, sir.
When do you think that 8,000 is going to be happening? What do you think?
Mr. Rennick is here, Judge.
When do you think? You think 6 weeks?
Sure.
All right. Sure. All right, I'll reset it 6 weeks, okay? Do the resetting there. Thank you. Devontae Gilbert.
He's here, Judge.
Okay, you ready?
Ready.
Mr. Dumas? I need to sign a resetting, please.
What are we doing again?
Your Honor, this is a bond hearing. I'm stepping in for Mr. Smith. He had an operation on medical procedure last week. This is reset from a previous bond hearing, UWI, in which there has been no blood results yet. My understanding was the last court hearing, we wanted to, I guess there's something mentioned in reference to December 1st to get the results. So you will want to go back and revisit possible bond conditions so that he may be released. And I do have argument efforts to
go ahead and argue.
Your Honor, he has been sitting in jail since this progress. We believe that there are conditions that could be satisfied. Mr. Hubert has strong family ties, which I believe were talked about in front of this court before. He also has strong church ties with Reverend Adolph in this matter. He is asking that he be released. He has no objection to either GPS or home confinement. He has no objection to possibly a monitor placed on him in reference to alcohol. He just does not want to be sitting in jail waiting to see if what the results might be. I believe most of the other things he has complied with probation, except for this offense. And he would like to start back to try to start continuing his restitution. So we ask that you consider.
Yeah. How's he paying his restitution? How is it?
I'm talking about his fines and fines and.
Oh, okay.
I'm sorry.
How's he doing that?
Well, he's not doing it sitting there.
No, I understand.
But he's got family that has, my understanding is he's got family that he was, they were ready to start back. And catch up on whatever he is.
Family's gonna pay?
No, I have a job, I'm working
Where?
at William Brothers Construction. And I
How
also,
much do you make an hour?
I make $18 an hour, so I also play the drums at Antioch, where I get $1,500.
You do what there?
Play the drums.
At church, at Antioch Church. So he'll be going back and forth to church or staying at home and the court, he will not be driving. Do you have a way of
Not my pastor said he will make sure I get back and church from home and work.
you will not drive an automobile?
Can't know that I was about to.
Yeah, grab
What's the status on the balloon? When's that everything?
Talked to them this morning. All the preliminary tests are done. They have to have it reviewed. The earliest that the results will be is Wednesday of next week. More likely it'll take 2 weeks. But we'll have it before the first of the year.
And like you guys like said, something not good.
Okay.
And Judge,
We won't have a hearing before the first. We'll have to have it.
One day, but
I presume.
I've been pushing
All
to get,
next week. We're working all next week, aren't we, on stuff?
next week. No, Your Honor.
No, we're done next year.
I will, as soon as I get the results in, I'm going to forward it to whatever attorney of record is. I know that Tom's showing up for Bruce, but Judge, you've heard these same arguments from Mr. Faggard, from Mr. Smith. You have been asking me to get the blood test results, and I've worked diligently to try to do that. There are a lot of factors that are out of control. This is as quickly as we can do it. It has nothing to do with trying to keep Mr. Joubert where he is, but we were also not with him whenever this alleged offense occurred on August 30th. We all want to know what the blood test results are before we do anything.
So we're gonna have a hearing set like in the second week of January. Yeah, I mean, y'all are ready to go, right?
We're ready, Judge.
Okay.
I would only ask that possibly that you would set something and let him determine, or his family determine whether or not they want to spend the money for that short period of time or wait till.
It was, but it's
Judge, you know what my position is about that.
$10,000 a month.
Judge, we have stated, let me clarify then on the record. You have stood with me about the argument that I've made in the past. I made a mistake placing this man on probation. I went out on a limb, gave him an opportunity based upon all the arguments that you're hearing here. When you look at his PSI, you see that he did not qualify for the probation that was given to him as far as getting it from a jury. And here we are.
But he got it.
He got it. And now I look really bad in making that decision.
No.
And I don't agree with setting a bond on one that he is not entitled to it by law. It is the court's discretion.
It's the court's discretion. He isn't, they're all.
He isn't entitled to it by law. You can, yes, sir.
It's going to set one and violate a law?
No, sir. No, sir.
Okay.
No, it's discretionary with the court.
Clear. Yes, it is.
It is.
I believe you also going to make the condition of home confinement.
I'm sorry. Yes. Bond's $10,000. You have to have a GPS device. You must be home confinement. You cannot leave the house. Except to go to the hospital. You understand? Are you going to be living with your family?
Oh, yes, sir.
Okay. Let them go out back and forth and take care of things. But you're going to stay in home confinement. We're going to set this for a hearing on the second week in January. That's all.
I have another one, Judge, here in Norman.
What are we doing on that?
Here in Norman is kind of ironic, it's Christmas time. If you take a look at what she's arrested for and what she's on probation for, she likes to shop. Except that she doesn't shop a little bit.
She didn't pay.
She doesn't pay. She had been out on bond.
What case is this?
This is Daniel's case.
Tiara
Norman.
Norman.
We were going back and
We got
forth.
2 cases.
And then Mr. Boyd realized that she was on probation and last week or the week before filed. Yeah, it's Christmas shopping.
How many years?
In the past.
Get Tiara Norman, please, if you'd be so kind. Norman, Tiara Norman, is she there? We don't have her back there. Okay.
Somebody stolen?
Well, it's a better return. Thank you, I'm happy to.
Yes.
Sorry, I didn't realize. Judge, may I approach?
Yes. Yes.
Going back to the beginning of the docket, village view.
Yes.
Police in custody, they were unable to bring him from the jail. Apparently there was some issue there. So we say a city reset till.
Okay, it is reset.
Thank you. Say something on that. Let you go. Yeah. Trying my best.
That's time, 7 minutes flight. He's here. I'm scared. He's been in and out. I think. Oh, okay. You're sorry. I've been very into my.
Hey, Don, on Willie Pugh.
Yes.
He's competent. What are we doing on this?
We're resetting it because they couldn't bring him from the jail. That's why I just talked.
Okay, they're not like late. They just didn't bring him at all.
You said there's some kind of an issue at the jail where they're not going to be able to bring him.
Okay. Then.
We probably get him the first week of.
This report on Dr. Khan dated December 3rd, 2025. I'm going to file this into the record. It'll be court's exhibit number 1 in this docket. 15-23631. And made part of the record is court's exhibit 1. The defendant is deemed competent to stand trial. When can we reset him?
Yes,
tomorrow.
Reset till after the first.
Why? Well, what are we doing? What are we going to do?
It's probably going to be set for a hearing on the motion.
Okay.
I can just go ahead and set it for him to mark in here.
I need to talk to him.
I mean, it will be after the first.
Yes, that's fine.
Okay.
I'll get with you all day.
Yeah.
Okay, thank you.
Okay, there's. He's already pleaded true.
He did. The state just filed an amended motion. I just got it this morning.
I don't have.
He just handed it to me this morning.
Okay.
No.
Okay. Well, then you need some additional time on it.
I'll set for a hearing in January, Judge.
And then Ronald Tyler. Ronald Tyler. No, nobody's.
Are we not doing anything on Tiara Norman?
He's out there signing up on time. Yeah, she's not able to be right.
Okay.
What'd you say on Tyler?
Mr. Gertz is here, but it's fine. They're doing work outside, Judge.
Hey, Tom.
Yes.
Come on up here for a second. Do you have a second? Thank you. You're on time. Where did he go?
He took his spot. I just all we have is his adult parents, sisters, and that things. He's there calling it up. It isn't solved from brain up. And Chris is talking about that after.
Cases involving Ronald Lee Tyler. Is that you, sir? Present with Mr. Gertz, your attorney and the state's attorney. Our plan is he's going to be pleading to 2 and 1 to be dismissed. Which one to be dismissed?
The one ending in 4-5, Judge.
Okay, 38245 to be dismissed. So the defendant will be pleading to 2 cases, which are called 21-38243 and 38244. Does the defendant waive formal readings of these indictments and arraignments? Can we proceed in summary?
He will, and we can, Judge.
In summary, sir, each of these indictments similarly allege that on or about August 19th, 2018 in Jefferson County, Texas, you committed the 2nd-degree felony in each case, an indecency with a child involving 2 different children. Do you understand what you are charged with here, sir?
Yes, Your Honor.
Each of these cases are 2nd-degree felonies. Can't get into the box in this program.
Every time I touch the sides or something, stuff's popping up. And
each of these cases, sir, are 2nd-degree felonies, which mean in each case, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, Your Honor.
I just wrote my name and then it erased immediately. So an agreement has been reached in these cases where whatever punishment shall not exceed a cap of 10 years imprisonment. This is for each case.
yes, Judge.
And are these sentenced to run concurrently as part of the agreement?
Yes, sir.
Okay, let me add them. And cause number 38245 will be dismissed as a part of this agreement. And also for 21-38244, in that case, a similar agreement has been reached by the parties where you would be pleading guilty. Whatever sentence shall not exceed a cap of 10 years imprisonment, which will run concurrently with the other case you are pleading guilty to. And those will be accomplished at the same time. What we're going to end up doing is accepting your pleas today and then postponing sentencing until a pre-sentence report is prepared from the probation office. We will all return back, add any additional information necessary, and then the court will make its decision on the sentence. Do you understand the plan?
Yes, Your Honor.
If I follow this agreement, sir, you have no right of appeal of your case in each case situation. Do you understand?
Yes, Your Honor.
How do you plead in each of these cases to these indictments in 38243 and 38244, guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Okay. Yes, Your Honor.
Let me show you here in each case. what's marked as States Exhibit 1. Did you sign those documents voluntarily?
Yes, Your Honor.
Understand them, discuss them with your attorney, or the contents alter and correct?
Yes, Your Honor.
States Exhibit 1 is tendered into evidence in each case.
We have no objection.
Without objection, it will be admitted. Among other things, this states you are mentally competent to enter your guilty plea in each case. It's freely and voluntarily made in each case. You understand and appreciate the consequences of pleading guilty. There's sufficient there is sufficient evidence here supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. Do you understand?
Yes, Your Honor.
And you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And you are totally satisfied with the representation provided by your attorney in each of these cases. And this says this is all true. So help you God.
Yes, Your Honor.
States Exhibit 1 will be made a part of the record in each case without objection.
No objection.
All right, what we're going to do is order a pre-sentence report in these cases, and we will return back. After that is accomplished, we will return back. When is our next setting?
You can do either January 29th or the 30th, the Thursday or Friday.
We should probably do Friday. I'm going to be in the capital trial in Houston.
All right, Friday.
So Friday.
On what's
I'll let you know if that goes long. It shouldn't, but
We can always move it if need be.
thank you.
So, do you understand in each of these cases, sir, you are looking, here are your options. You could be sentenced to prison for a term of no less than 2, no more than 10 years confinement. You could be placed on deferred or unadjudicated probation in each case, where you are not found guilty and placed on a form of probation. And then I think regular probation is not an option in these cases by law. Isn't that the understanding? So those are your only 2 options here, and your attorney will be able to discuss with you the ramifications of each of those. And so also you will have to register as a sex offender. I don't think that has to be done today. It's when you.
It can be done in sentencing.
It's when you are sentenced.
And
But that has consequences to it.
Yes, sir.
That your attorney has gone over with you. When we go over that at the time of sentencing, there will be a document, and I'm going to review with you what the consequences are and what your requirements are for registering regularly. Failing to register properly under the law can result in a criminal act that you could be prosecuted for. So those are some consequences and requirements and responsibilities that you're going to have to deal with because of this matter. All right, we've reset it until what day?
Tentatively January 30th.
Okay. January 3rd, 2026. Try to get used to that. Also on that day, if all of this is done, the court will sentence you, and then this other case 38245 will be dismissed as part of this agreement. Anything else?
No, Judge.
That is all. Thank you for your recess on this. Anything else? That is all. All right. Let us get ready for trial. Mr. Patel's.
That takes it. We'll let you have problems if you show up.
The other.
So let's just.
So maybe I do.
I'd like to keep on.
Maybe I do.
Well, yeah, that's on the 26th, so I have that back over there.
Okay.
Right anywhere to kind of. Sounds like Mr. Woods, just, you gotta come to. Yes, sir. Thank you.
Let's get ready for trial, everybody. Please.
Well, we're not gonna end up taking, yeah, you're welcome to have a seat. All right, this is a zoning violation citation having to do with open litter, open storage, 515 Walnut Street, non-compliance with the trash notice, written by James Ballard, the city's zoning enforcement officer. Mr. Reed, what's the status here?
My understanding is, Your Honor, and is laid out in the motion, that it's still in violation. What we have here, Your Honor, is our belief based on the past pattern, and is essentially utilizing the property, will stage or store junk, garbage, rubbish, scrap materials, and from time to time take them off the property, back onto the property. I attached a log showing the city's contact back to 2021 with this filing, as well as photographs. I also attached to our pleading.
Present before the court is Mr. Epson, right?
Yes, sir.
We have Mr. Harris from the prosecutor's office and Officer Evans from probation. We're here today, Mr. Epson, because I received a report that alleges that you have violated the terms of your supervision. What are the allegations? Officer Evans? I guess I could read them from the email, but
I think this is the correct one. On Mr. Ibsen's in violation of rule number 5, and then on 8/22/25, he failed to report for a scheduled office visit. On 10/17/25, he failed to report for an order to report. Rule number 7, and that on March 3rd, he was randomly drug tested and was positive for oxycodone and marijuana. On July 21st, 25, he was found confirmed positive for oxycodone, benzodiazepine, and marijuana. On 12/10/25, he was positive for oxycodone. Rule number 13, on 9/2/25, he was unsuccessfully discharged from Woodhaven. And on 12/5/25, he was unsuccessfully discharged from Woodhaven PHP after he left the program against staff advice, resulting in his arrest.
Mr. Ibsen, you have the right to be represented by a lawyer in these proceedings. If you can't afford one, I will appoint a lawyer for you. Do you want to be represented by a lawyer?
Yes, Your Honor.
You going to hire one or you need one appointed?
One appointed.
All right, Ms. Carrillo has an affidavit that tells me in writing that you don't have the money to hire a lawyer. Who are we appointing? I do find that you're indigent for the purposes of hiring a lawyer in the case. I'm going to appoint Ms. Chambers to represent you. You have her contact information there. We're also going to send her an email today that lets her know that she's been appointed. And I'm going to set this for a final hearing in about a week to 10 days. Is there anything that you would like to tell me today?
No, Your Honor. Thank you, though.
All right, court finds that there is probable cause to believe you have violated the terms of your supervision. I'm going to hold you in jail until the next hearing. Yes?
Your Honor, I mean, I just want to come out and say that, yes, I did check myself out of treatment. I remember that you guys sent me back there and I actually graduated that treatment. It was a nice treatment center. The only reason, Your Honor, I left that treatment was because I was tired of feeling institutionalized in that place. I have a 2-year-old son at home. It was coming up on Christmas. I wanted to spend at least a day or two with my son and my family. You know, I've graduated 2 programs for you, Mr. Oda, Protea and Woodhaven, you know, and I just would like the possibility maybe be able to go back. I know I can graduate this program. I know I've proven it before to this county. I just, but this jail is not it for me, Your Honor. I'm ready to, get my life together. 27 years old, 2-year-old boy at home. I can already tell his mother and me is getting to the point to where it's either, Devontae, get your life together, or it's child support and, not being with your son. So if I could just get that possibility of going back to treatment.
All right, we'll talk about it at the final hearing. I'm going to hold you in jail until then. I'll see you in a week or so.
All right, thank you, Mr. Oda.
State of Ohio versus David Durham. This is case number 24 CR 42246 and 25 CR 42480. Present before the court is Mr. Durham, right? We have Mr. Harris from the prosecutor's office and Officer Evans from probation. We're here today, Mr. Durham, because I received a report that alleges you violated the terms of your supervision. You did not report for your office visits, and you tested positive for meth when you were arrested on the charge. You have the right to be represented by a lawyer in the case. If you can't afford one, I'll appoint a lawyer for you. Do you want to be represented by a lawyer? Ms. Kuroko has a waiver that tells me in writing that you don't want to be represented by an attorney. I'm going to accept your waiver of counsel. Do you admit or do you deny that you violated the terms of your probation?
I admit, sir.
Based upon your admission, I find you have violated the terms of community control. Mr. Harris, anything from the state?
Your Honor, he has 22 days of jail time credit. My memory of this is he had a substantial amount of restitution that was due, and I think he has a history of failing to appear and coming back to court. So it's kind of weighing those two options. I know that the victim would like to get the restitution. However, it's creating a problem because Mr. Durham does not follow through with coming to court.
Yes, say something, sir.
Officer Evans, what's the recommendation of probation?
Your Honor, according to Officer Rose, it looks like she would like Mr. Durham to complete a new treatment assessment, comply with all those recommendations, be placed on EMHA with work privileges, and then be placed on a payment plan for the restitution.
Sir Durham, what do you want to tell me?
Well, you knew that I had cancer. I've been battling cancer, and I was in the hospital when I was supposed to come and see her. We had stayed in contact, and I understand that wasn't good enough. I should have came and seen her. I just finalized my last treatment last week, and am able to go back to work now. Clear bill of health.
The meth probably doesn't help much with the cancer treatments, right?
What's that?
The meth?
No, sir. No, that was a mistake I made, and I'm here to admit that.
So here's the thing, Mr. Durham, I 100% disagree with Officer Rose's recommendation in this case, and I think that you should spend the next 90 days in jail because I don't believe that you have any intent of paying this. I don't think that you have any ability to pay this. It's not really going to help you weighing in.
I have inheritance coming after the first of the year, and I was going to pay this completely off.
Yeah, Mr. Durham, I hear that a lot.
Well, I mean,
I got money coming.
If I paid a substantial amount on it when this first happened, and you knew I was sick, I will not let you down, Your Honor. I promise you. I just beat cancer, and I am in no way, shape, or form here to let you down. You have my word that I will pay this. I'm not gonna go back on my word again. I've got too much to lose, Your Honor, and I value my life too much now to be taking anything into. I'll do whatever you need. I will pay this. I promise you. On everything I am, I will pay this. I could have $1,500 by next week.
Are you done, Mr. Durham? Because I don't want to interrupt you again.
I'm sorry, Your Honor.
Are you done?
Yes.
So, as I started to tell you before I was interrupted, I don't agree with Officer Rose in her recommendations, and I think that you should spend the next 90 days in jail. However, Officer Rose knows you better than I do, and her recommendation, for some reason, I can't explain why that is, her recommendation is to stick her neck out for you and say, I think that Mr. Durham should be able to go home for Christmas because I think that he is going to do the things that he is going to do. I don't think that, Mr. Durham. And we're going to find out pretty soon who was right and who was wrong about this case. So I am going to release you from jail today. I'm going to place you on electronically monitored house arrest. You can go to your medical appointments and you can go to work and you can go to treatment. Other than that, I want you home, and we're going to set this for a final violation hearing. Technically, it's a final violation hearing because we'll be deciding the outcome of it at the end of January. So we'll set it for a final violation hearing in January, and we will talk about a couple of things. We will talk about your drug treatment and how that's going. We will talk about all your clean drug tests, which hopefully that will be happening. And we will talk about the amount of restitution that you have paid and what your plan is to get the rest paid. So you're not disappointing me in the least, Mr. Durham, but if you don't do the things that you're supposed to do, you're going to make Officer Rose look bad.
Yes, sir.
Okay?
Yes, sir.
All right. I do find I do find that you violated the terms of your supervision. Let's set it in January for a final hearing and see where we're at. Okay? Ohio versus Lisa O'Leary, case number 25 CR 42563. Present before the court is Ms. O'Leary, right? We have Mr. Harrison, the prosecutor's office, and we have Officer Evans from probation. We are here today, Ms. O'Leary, because I have received a report that alleges you have violated the terms of your supervision, that you tested positive for meth on December the 11th, and more importantly, we did a home visit and there were about 200 guns in the house in which we did the home visit. You have the right to be represented by a lawyer in these proceedings. If you can't afford one, I will appoint a lawyer for you. Do you want to be represented by a lawyer? Is that a no?
No.
Ms. Carrilco has a waiver that tells me in writing that you do not want to be represented by a lawyer. I'm going to accept your waiver of counsel. Do you admit or do you deny that you violated probation?
I admit.
Based upon your admission, I find you have violated the terms of your supervision. Mr. Harris, anything from the state?
Your Honor, she has 61 days of jail time credit. And my understanding is probation's recommending that she have a new assessment be placed on EMHA, and they're looking at a sober living placement for her.
Officer Evans, anything from probation?
Nothing further, Your Honor.
Ms. O'Leary, what do you want to tell me?
I want to go back to my brother's house. That where the guns were was at my boyfriend's house. Was it where I should have been? I should have been at my brother's house.
Is there anything else you want to tell me?
No, I mean, I did meth, and I do regret it. I don't want to ever go back that way again. And if you let me go home, there's not going to be another peep out of me. I'll do everything I have to do.
You know, Ms. O'Leary, I'm trying to figure out if I've had a more dangerous situation that my probation officers have walked into in the year 2025, and I don't think there is a more dangerous situation. If they walk into a house that is wall-to-wall guns, that is terrible. And I'm not inclined to release you from jail today. I do want to get some more information on your residency options. If we're not going back to the boyfriends and we're going to the brothers instead, that might make a difference with me. So what I'm going to do is I'm going to set this for a final hearing. Let's do that early next week. So we're going to set it for final violation hearing early next week. And you better have a better plan in place than I might go to my brother's where there's not going to be a lot of guns.
There's no guns at my brother's. There's nothing. He don't do nothing. He works second shift, and he don't drink. He don't smoke. He don't smoke cigarettes. He don't do drugs. He's a workaholic.
All right. Officer Evans, can we go ahead and have in the interim, Community Corrections check out the brother's house to see its level of appropriateness? Do we have that address for her on that address on file? Do we know?
I'm not sure if we do have it, but we will get it and I will make sure that happens.
All right, we'll talk about it at the final. I'll see you next week. I am going to hold you in jail until the final hearing. We'll see you next week.
All right, thank you.
This is the case of the state of Ohio versus Amber George. This is case number 24 CR 41444. Present before the court is Ms. George, right?
Yes, sir.
And we have Mr. Harris in the prosecutor's office, Officer Evans from probation. We're here today, Ms. George, because I received a report that alleges you have violated the terms of your supervision. You didn't report for a drug test on December the 4th. You were in possession of meth on December the 11th at a home visit, and you were positive for meth when you were arrested. You have the right to be represented by a lawyer in the case. If you can't afford one, I'll appoint a lawyer for you. Do you want to be represented by a lawyer? Ms. Kuroko has a waiver that tells me in writing that you don't want to be represented by an attorney. I'm going to accept your waiver of counsel. Do you admit or do you deny that you violated probation?
I admit that I did it.
Based upon your admission, I find you have violated the terms of supervision. Mr. Harris, anything from the state?
Your Honor, at this point, she has 93 days of jail time credit. She's created a history of noncompliance. I know that probation was recommending CBCF evaluation or revoke her at this time.
Officer Evans, what's our thought about Ms. George?
This is the third PV that we have been here on since we allowed her to complete residential treatment after she absconded last February to Kentucky to also pick up new felony charges. I believe if Miss George does want the help, I do want to provide that. I think a CBCF right now is the answer to that or the best option for her. And that's the direction I'm willing to go to continue to her in REACT and continue her on community control with us.
George, what do you want to tell me?
I would like to say that between the last time I was here and this time, I have been searching places for better IOP rather than Brightview, and I was supposed to have an assessment at the Centers for Addiction Treatment last Friday. Obviously, I missed it because I was incarcerated, but I am actively trying to seek better IOP and mental health. I also started mental health with Ray of Hope. So I am actively trying to get my mental health and my addiction under control, Your Honor. It's something that has continued for a long time and there's no excuse for it. It's my decision. I do have mental health issues, and finding mental health counseling was my top priority, which I now have since my insurance has gone through. It's through Ray of Hope, who also does my my mental health medication. I have a wonderful counselor there. I just started with her. She has a good plan for me in place to do telehealth once a week with her. I continue to do my Brightview because I have to through the state of Kentucky as part of their aftercare with my treatment over there. I do have my PSI this Friday with the state of Kentucky, and I do have court again January 14th with Kentucky. So I would ask that, I know it's a lot to ask, but now that I do have my insurance and I do have my mental health plan in place, that I possibly could be released on an EMU again to prove to you that with my mental health in check and my counseling that I can do this, Your Honor. I know that I can.
I don't think that you can, Ms. George. I think for me to release you on EM to do the same thing that we did a couple of weeks ago and expect a different result doesn't make any sense to me. I do want to have you evaluated for a community-based corrections facility. I know I sent you to Monday, I think in 2020. It seemed like you got a lot out of that program at the time. We need to take a look at doing something different. So I'm going to set this for the final hearing in the next couple of weeks. And let's do a CBCF evaluation and see what our options are. We'll come back at the final, discuss what our options should be.
Yes, Your Honor.
All right, that's all.
Thank you.
We'll go back on the record in Ms. George's case.
So when I caught my possession charge, do I have a new charge? Like, do I have to go to court in Mason tomorrow, or is that staying up here as a probation violation?
They are probably separate. There's probably a charge in Mason that ultimately is going to make its way here for a new charge, but I don't know what's going to happen in Mason tomorrow. But that's different. Even though it's the same underlying facts, it is a different case, and it'll probably be another number here in our court.
Okay.
All right, that's all. Next is the case of the State of Ohio versus Thomas DeLong, case number 16 CR 32375. Present before the court is Mr. Harris from the prosecutor's office and Officer Evans from probation. We are here today for an early termination hearing. Mr. Harris, anything for the state or on behalf of the victims?
Your Honor, this matter was, as the court will recall, was very serious. The defendant did a substantial amount of prison time. The court did grant him judicial a little over a year. He was placed on 3 years. We have attempted to contact the victim. We did that at the judicial release hearing, as well as recently we were unable to get victim's input. I believe a letter was sent to the court at the judicial release hearing, purported to be from the victim. There were serious, substantial, life-changing injuries to the victim in this matter. This was involving a firearm, and victim was actually shot. It were life-threatening injuries. As far as any supervision on the defendant, we do not feel a little over a year is substantial enough. And we would object to termination of his community control at this time.
It's not a year. He's been on supervision for 2 years, right?
He got out in, that is correct, 2023.
I believe he's been on non-reporting probation for the last year.
Right, because we had an early termination recommendation a year ago, and we held off on it, and we put him on non-reporting probation for that period. So he's been on 2 years. I mean, I get your point. But if he had served his entire sentence, he'd be out by now, right?
That would be correct.
All right, I'm going to grant the early termination. That's all.
Edward Drucas on behalf of Jacqueline Murray.
Oh, they're good.
She'll be approaching. Your Honor, there's going to be a misdemeanor plea to break.
Yeah, we'll wait for the defendant. Is there
there's a plea form. I'm going to have her sign it when she comes to the podium, along with the advice of rights.
I have a misdemeanor form that indicates that the defendant will be pleading guilty to the charge of B&E of a motor vehicle less than 293-day offense. Upon her successful plea to that charge, count one would be dismissed. There is an There's also the understanding that the defendant is agreeing to pay $180 restitution. That's the court's full understanding of the agreement.
Yes, Your Honor.
Yes, Your Honor. And can you state your name for the record?
Jacqueline Murray.
May I have her sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
State your name, please.
Jacqueline Murray.
All right. Ms. Murray, it's this court's understanding that you're going to plead guilty guilty to the charge of breaking and entering a motor vehicle
Yes, Your Honor.
with less than $200, basically. That is a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court cost. The fine could be increased 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
I understand.
All right. Still wish to plead guilty?
Yes, I do. Yes, I do.
How do you-
Your Honor, I plead guilty.
All
I did it.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
Okay, you signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No, Your Honor.
Anybody threaten you or coerce you?
Oh,
Doing this voluntarily?
yes.
Of your own free will?
Of course.
Because you believe that you are indeed guilty of this offense?
Yes.
Okay. Find my complaint here. On the date of March 10th, 2025, location of 2451 Twin Lakes Drive, Pittsfield Township, Washtenaw County, State of Michigan. What'd you do to various vehicles, but what'd you do on that date that makes you think that you're guilty?
I entered vehicles and took property from the vehicles, said vehicle.
Say again?
I took property from said vehicles.
All right. You went up to these vehicles. You didn't have any authority to enter these vehicles. Is that correct?
Yes.
And you just either unlocked them somehow or another. You opened the door to the vehicle and you took property located within those vehicles.
Yes, Your Honor.
All right. You did that intentionally?
Yes, I did.
All right. Ma'am, I do have to advise you that if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing that you commit misconduct as defined in the Michigan court rules, you would not be entitled to any sentence evaluation and would not be able to withdraw your plea. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
People are satisfied.
Was the value that was taken under $200?
Well,
Yeah.
it's going to be of some value.
Oh, some value.
That's why I didn't address it.
Okay.
If you want to go ahead and waste my time, go ahead.
Sorry, Your Honor. Defense is satisfied.
Court will accept the defendant's plea of guilty to this offense to count 2. Count 1 is dismissed. Defendant is referred to probation, pre-sentence investigation and report. Sentencing will be
January 14th.
January 14th. Are you expected to get out anytime soon?
March.
You don't get out until March.
Oh, well, I'm gonna try to put my good time cards in, but yeah, March 14th.
Let's do this. I'm going to do 28. No, I understand that.
Yes, sir, 28th.
January 28th, 2026. We'll make that at 12 noon. Okay, I'm putting it a little further out, but you're not gonna.
Oh, yeah, no, I'll be here. I ain't going nowhere.
Are you done with the cases before me yet?
I don't know. I might have one more.
I think they're done.
I hope we're done.
Well, what's that mean?
I hope we're done.
I like seeing this one of you. The one that we first got. Oh my God, you were.
Hey.
All right.
You know, sober me, a better me.
Yes, it does. You take care.
Thank you, Ron.
Bond will continue.
Thank you.
Court calls the case, People versus Kyra Griffin.
Pastor Thomas for the people.
Good morning, y'all. Please preside on the court. Brandon Bird on behalf of Shakira Griffin. Ms. Griffin, can you please step to the podium and state your full name for the record?
Come on up.
Sorry.
Come up to the podium. What's your name?
Chikira.
Chicago Griffin?
Yes.
Okay, thank you.
Yes, we like to set this matter for a final settlement conference, Your Honor.
Jury final settlement conference will be set February 6, 2026 at 9 a.m. Jury selection, February 9th, 2026 at 8:30. Both of those proceedings are in person.
Sounds good. Thank you, Your Honor.
Thank you. Bond will continue. Thank you, ma'am.
All right, Mr. Yeah, you go.
Court does call the cases of the people versus Carlos Max. Okay.
Yes, Your Honor, if it please this honorable court again. Brandon Bird on behalf of Carlos Mack. Mr. Mack, can you please state your full name for the record?
Carlos Mack. Thank you.
Public defender Lauren Perry. I'm the case ending 1404.
1404. All right. What are we doing?
Oh. You go first.
Your Honor, on my case, I'm requesting an adjournment, Mr. license case. We're just gonna see if and when Mr. Mack is released, if he can go to Secretary of State and try to get his license.
Respectfully, Your Honor, I did speak to Sister Prosecutor, and we do have a plea that my client is willing to take today, would be to dismiss the operating while intoxicated and plead to the amended charge of operating while visibly impaired. I need you to sign right. Thank you.
Plea form the court has is indicating that he's going to plead to the charge of operating while visibly impaired, the 93-day offense. Upon a successful plea to that charge, count one, operating while intoxicated, would be dismissed. That's the court's full understanding of the agreement. Is that correct?
Yes, sir.
Counsel?
Correct, Your Honor. Sorry,
Thank
sorry,
you.
Your Honor.
No, it's okay. You're busy doing something else and ignoring me.
Oh, no.
Can I
no.
have him sworn, please?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Carlos Mack. Before I go on to that, Miss Perny, I will adjourn the 1404 case. I'll adjourn that. Will the 7th work? Well, he's got to get out.
Yeah, I don't know. Obviously, how long I'll be in custody, so.
Why don't I just adjourn this out to the 21st of March?
Yes.
January 21st, 2026 at 9. If he's not out at that point, we'll at least see him and figure out where we go on that one.
Thank you.
All right, we'll continue on that case. All right, sir, it is this court's understanding that you're going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, a $300 fine plus court costs. The court could order community service, any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Yes, sir. Yes, Your Honor.
And understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right, you signed an advice of rights form, is that correct?
That's correct, Your Honor.
Any question regarding any of those rights?
I'll say, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy there. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yep. I would say.
You understand you're giving up those rights?
That's correct, Your Honor.
All right. You understand that you're giving up your right to appeal of right?
That's correct, Your Honor.
Are you on probation or parole?
No, sir, Your Honor.
Has anybody promised you anything other than
No,
what's
Your
been
Honor.
stated here today to get you to plea?
No, sir, Your Honor.
Anybody threaten you or coerce you?
No, sir, Your Honor.
You're doing this voluntarily?
Yes, sir, Your Honor.
of your own free will,
That is correct, Your Honor.
and because you believe that you are indeed guilty of this offense?
That is correct, Your Honor.
They had these out like they did on the other ones. Hang on, I'll fix that one. They put that there. Sir, on the date of January 28, 2023, at the location of Ellsworth Road near Ridgewood Drive, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
That is correct, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
That is correct, Your Honor.
What do you have and how much?
I'm not quite sure, Your Honor.
Not quite sure how much, but you did.
Yeah, what I was in.
Did the police stop you or was there an accident?
I was stopped, Your Honor.
Why'd they stop you?
Probably headlights. I was impaired.
Well,
Yes.
okay. Do you know why they pulled you over?
No, sir. I was impaired. That's the reason.
Okay, and that was exhibited by some erratic driving and your headlights weren't on, or what would they know from the outside to pull you over that you're aware?
Driving on the line.
Pardon?
Driving on the line. I would have to ask the officer.
Yes.
Sir, at the time that you were operating that vehicle, was it 23:37 hours as in dark outside?
That is correct, John.
Was your vehicle, did you use your headlights on your vehicle?
That was the fog lights. No, ma'am.
You had,
You had running lights on, but no headlights?
can you just answer her question?
No, I do not have.
Did you have headlights on?
No, sir. No, Your Honor.
And so you didn't have the proper equipment
That is correct.
to operate a vehicle in the dark,
That is correct.
right? And that's why they pulled you over. Is
That
that
is
correct? Thank you. You're not disputing the right of the police to pull you over.
No, sir. No, Your Honor.
And were you ultimately arrested?
That is correct.
And were you taken to the hospital or were you taken to the police station?
I went to the hospital and then to the police station.
Or did they do a blood draw?
Yes, they did.
And what were the results of the blood draw?
0.17,
0.177?
I would believe.
Are you disputing those results?
No, Your Honor.
All right. And don't have a reason to dispute those results?
No, Your Honor.
On taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
That is correct, Your Honor.
Sir, I would have to let you know that if between the time of sentencing and between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, that you would not be entitled to rely upon any sentence evaluation, as the court would no longer be bound by that, and you would not be entitled to withdraw your plea. You understand that, sir?
That is correct, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court rule? Would it be proper to accept this defendant's plea?
You are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be January 14th, 2026, 9 a.m.
Permission to address bond, Your Honor.
Briefly.
Respectfully, Your Honor, my client has been in since, I believe, 11/19, roughly around a month now. If we do wait to the January 14th date, he would have almost spent 60 days in the jail, which would be over half of the maximum penalty for this charge. He does understand the severity of his actions. He just displayed to the court that he's not trying to waste the court's time. Took accountability for his actions, understands the ramifications of what could happen if he doesn't follow the court's orders, and respectfully, we're asking to reduce his bond to a personal bond, Your Honor.
Your Honor, the people's position is that we'd like to have Ms. Pilar meet with him before that, and we trust her judgment and ask that the court continue to bond him out.
And that's what I'm going to do, which is customary for this court. I'm not going to do anything regarding his release till he's met with the probation. In particular, given the circumstances he didn't make it very far from arraignment before he violated the condition of his bond. So motion for bond reduction at this time is denied.
Why'd you hear me out? Yeah.
Court does call the case of the People versus Marcus Stewart. That it for you, Mr. Bird? Is that it for him? That's it?
Yes.
You tried to hide behind Miss Pate and it didn't work. I saw you. Marcus Stewart.
On behalf of Pittsfield Township.
Good morning, Mr.
Bill P8643 on behalf of Mr. Stewart.
Mr. Stewart, can you state your name, please, sir?
Marcus Stewart.
Okay, I have two cases here. What are we doing?
In the township case, Your Honor, he does have a valid license, so he's going to admit double parking. He'll probably need to waive the reading and stand mute.
Has he been arraigned on that at all?
I don't think he.
So, counsel, on that case, you're waiving reading of the complaint on the Pittsfield Township case ending in 0894,
Correct, Your Honor.
and your client is standing mute. Defendant having waived formal reading standing mute, the court will enter a not guilty plea on his behalf. And then the people are adding a count 2 of double parking.
Correct, Your Honor.
And upon his plea to that, then count 1 would be dismissed. Is that your understanding, counsel?
Yes.
All right. And so, Mr. Stewart, do you admit responsibility to the fact that on May 20th, 2015, that was like 3. Anyway, May 20th, 2015, Packard Road near Gulfside Road, Pittsfield Township, Washington County, State of Michigan, that you double parked the motor vehicle?
Yes.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180. When do you think you can get that paid, sir?
I can have that paid within the next 2 weeks.
All right, get it paid before the end of the year. Can you get it paid before the end of the year?
Yes, sir. Yes, Your Honor.
So just pay it by December 30th, 2025. All right. Then on this other case, what are we doing?
Your Honor, on that one, we're just going to request an adjournment for discovery.
And if I may, Your Honor.
Yes.
Assistant Public Defender Lauren Perry on behalf, well, not on behalf of Mr. Stewart. I just want to inform counsel a substitution is needed on
Oh, shit. Okay.
0547. We're still the attorney of record in the ROA. So, Ms. Boyles, you can email me directly. I can, we can get it done, or you can contact the public defender's office.
Okay, I'm just looking. I thought we already filed that one. It may not have been.
You know what? You're right. I do. I actually have it.
I only have an appearance.
I have substitution of counsel that I signed actually back in November.
JIS just is not updated.
It's just JIS is not updated. All right. So no reason to yell at the attorney, Perry. She did everything she was supposed to do. I knew that. I was going to defend her.
Mr. Stewart.
What'd you say?
I just don't want any confusion for Mr. Stewart.
He's not confused.
Well, good.
Counsel's not confused. You were the only one that was confused.
I was.
I had it. I got it. All right. So anyway, counsel, you're looking for an adjournment?
Yes, please.
Will January 7th work for you?
Yes.
All right. I'll adjourn the matter to January 7th, 2026. 9 a.m. or as your invite indicate. Bond will continue. All right. Thank you, folks.
Thank you, Your Honor.
Thank you.
Court does call the case. People versus Marcus Jackson.
David I. Goldstein appearing on behalf of the defendant.
Marcus Jackson. Thank you. I will also sign the substitution on that.
Thank you, Your Honor. Your Honor, Ms. Feltus and I have discussed this matter. Mr. Jackson has several felonies pending in circuit court. In fact, he has a pretrial this afternoon. My anticipation is this case is going to be wrapped into whatever resolution in those cases. So if we can have till the 21st of January, we should be able to get things taken care of.
Turn the matter without objection, January 21st, 2026, 9 a.m. Bond continued.
Thank you.
Thank you. Thank you, Mr. Jackson. Court calls the case of the people versus Kristen Dameron.
Mr. Feltus for the people. Good morning. Your Honor, we have come to a resolution. Mr. Dameron has given me permission to admit to no proof of insurance on his behalf.
And that is the offer to add count 2 of no proof of insurance, 257328, I believe, Your Honor.
328.
Okay, that's correct.
And then count 1 would be dismissed.
Yes, Your Honor.
Ms. Perry, on behalf of your client, do you make responsibility to the fact that on November 1st, 2025, at location of US 23 in Pittsfield Township, that upon request of a law officer, they failed to provide proof of insurance?
I do.
All right, court will accept that admission. Count 2, count 1 is dismissed. Fines and cost of $155. Do you know when they can get that paid?
He's asking for 2 weeks.
Tell them they pay it by December 30th, 2025. Why is he loitering? Court calls case people versus Michelle Campbell.
Mr. Feltus for the people in both matters.
Did they say goodbye? He's just loitering. It's like hovering over Cook.
It's working very hard.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Campbell. Ms. Campbell, state your name for the record, please.
Michelle Campbell.
Thank you, ma'am.
Morning, Mr. Simpson.
Good morning.
Your Honor, an offer was made on this case. Ms. Campbell and I did have an opportunity to discuss it. We're just hoping, I'm hoping to check in with the people to see if there's any additional surveillance footage. I have not communicated that request to them yet. So if that's a surprise, that is why. So I will get in touch with Ms. Cook and Mr. Cook and Ms. Feltus about that request.
And I will do community service.
Already taking hits. Actually, that was probably a promotion. Anyway.
So that's my request there. I'm just asking for an adjournment. I do have a treatment request as well. Ms. Campbell is up before Your Honor tomorrow on a PCC. I believe it's a resisting and obstructing charge. I think there's an agreement there for Ms. Campbell to be released to treatment. I'm asking for release on this case as well. If the court and the people are amenable to that, I'll submit an order.
Any objection to that from the people?
The single, we have talked about it ahead of time, so I didn't know it was coming, but the concern I have is it looks like we might have had failures to appear along the way here. So I'll leave it in the court's discretion, but that would be the one sort of asterisk I would point out. To the court.
All right. But I think her order includes release on a GPS if she's going to go. So, hey.
I feel a lot better.
And that's the way the order would read, because I think the other order reads that way.
Yeah.
So if you submit an order for release to treatment on these cases,
okay. All right.
All right. I'll adjourn it to the 7th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Take care. Court calls the case of the people versus, is it Richland? Okay.
That's felt this for the people.
It's probably not. Okay.
Assistant Public Defender Natalie Pate, with my behalf of my client, he stands to my right. Please state your name for the record, sir.
Richland Decay. It is Decay. Yes. Okay. Hey, I got it.
And Your Honor, this is we're going to move to dismiss.
Certainly no objection.
Case is dismissed. Thank you.
Thank you, Your Honor. Thank you.
Case of the people versus Ishmael Davis.
Felt this for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Davis. Mr. Davis, state your name for the record.
Ishmael Alexander Davis.
Thank you, sir.
Your Honor, we have been here a couple times. We're waiting for Mr. Davis to be released to treatment. I'm asking for an adjournment again for that purpose. Hopefully, once he completes treatment, we can come to
a resolution.
the resolution. We've been still trying to work on a hold out of Wayne County that no one can find. Mr. Davis and I worked yesterday for like an hour trying to calling all these police departments and courts to see where this hold is out of, and we can't figure it out. So we're still working on that. That's what's keeping him up, holding him up.
Are they not releasing him to treatment here because of that hold?
Right. We thought it was a hold out of Third Circuit. However, we arranged a video hearing. He saw Judge Ramsey in the Third Circuit, but there's no warrant on that case. So we just can't find where this warrant is coming from. So I'm still working on it.
You can't.
So it's the hold, if the court wants to know, the hold in X jail says Wayne Police Department. I've called Wayne, the city of Wayne Police Department. I've called the court and they have nothing on him. So we're chasing it down.
All right, here's what I'm going to do. I'm going to adjourn it to January 21st, 2026. That's a bit of time out there. All right. And because we can't.
Yeah.
Okay. And then, all right, in this case, this bond will continue. Council approach on a separate matter.
Attorney on behalf of Mr. Ducia. Your Honor, I don't believe Mr. Ducia is present. He, if the court can remember, the last hearing was in the hospital. The hospital sent information. He informed me he was readmitted into the hospital. I communicated with him yesterday. So that's my most recent update that I have for him.
So he's back in. He was out and now he's back in.
Right. He is up for PCC before you tomorrow as well. Both of these cases have kind of been tracking
each other along. All right.
Did the hospital send anything to the court?
I think before.
They definitely did before. All that.
I don't know this time.
I don't have anything, or at least nothing has come directly to my attention on that. Here's what I'm going to do, though. I'm going to adjourn this out to January 21st, 2026, 9 a.m. And just indicate to council to get us information.
Sure.
On that. All right.
January 6th, Your Honor?
No, I went to the 21st.
Oh, I'm sorry. Thank you.
Because he's going in and out, and then there's going to be another case that's going to be up tomorrow that will have to coincide with that.
Thank you, Your Honor.
All right, thank you. Court calls the case People versus Leo Stringer.
Yeah, the Assistant Public Defender Natalie Pate with and on behalf of Mr. Stringa, who stands to my right. Please state your name for record, sir.
Leo Stringer. All right, I have two plea forms, both indicating that he's going to plead no contest to the charges of retail fraud in the third degree, the 93-day offense. Upon his successful plea in each of those cases to that, and on the form for 0612, he's pleading to count two. It says count one, but I think he's pleading to count two on that case.
Correct, Your Honor.
Just so that we're clear on that. Well, no.
No, on 0612, he's pleading as charged to retail fraud in the third degree. And then in 1106 is an added count to a retail fraud in the third degree.
Correct.
Hold it. So I see. That is count one on that form. That's also part of the dismissal of retail fraud second in the other case.
Yes, correct.
Though in the other case he's pleading and it's going to be dismissed on that accord. Got it. Okay, I now follow. All right, and then also that he's going to plead no contest in the case 612, which is actually this case. and plead no contest to an ag count two in that case. All right, so I'm not sure why I have all this on the form. I get it. I see.
So thorough.
Yeah.
Yes, Your Honor. Yes, you'll be pleading as charged the retail fraud third in the case ending in 612, and in the case ending in 1106, he's pleading to the
added count
out.
two.
Yes.
Yeah, I have him sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
State your name, please.
Leo Stringer.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to two charges of retail fraud in the third degree.
That's correct, Your Honor.
All right. Those are misdemeanors, punishable by up to 93 days jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum amount of the fine. You understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
Two things about a no contest plea. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest these charges. You understand that?
Yes.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
You still wish to plead no contest?
Yes, Your Honor.
To the charge of retail fraud in the third degree as contained in the case ending in 0612. How do you plead?
No contest.
To that same charge as contained in the case ending in 1106. How do you plead?
No contest as well, Your Honor.
You understand that by pleading no contest, you will not have a trial of any kind.
Right. Yes, I give up those rights.
All right. So you understand that you're not going to have a trial. You understand you signed an advice of rights form. Is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. You understand that those are your rights, which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights that are contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Appeal them, yes.
No, you understand you're giving up your right to appeal of right.
Oh, yes. Yeah.
Are you on probation or parole?
No, not anymore. You discharged me last week.
And sentenced you to jail?
Yes, sir.
Yes.
So he's not.
He's not on probation.
Yes.
Anymore. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or forced you?
No.
You're doing this voluntarily?
Yeah, my own accord.
And of your own free will?
Yes.
Court has been provided 2 police reports. The first police report dealing with case 0612, Pittsfield Township Department of Public Safety report for their case number 256458. And in the other case, 1106, Pittsfield Township Department of Public Safety report for their case number 258906. Any objection to the court having reviewed those reports?
No, Your Honor.
No.
Based upon a review of those reports, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of each of these counts of retail fraud in the third degree. Mr. Stringer, I have to advise you that if you commit misconduct as defined in the Michigan court rules between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation and or recommendation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
No, Your Honor.
No.
Hang on one second. And has the court complied with the court rule?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea in case 0612 to count to the single count in that case of retail fraud in the third degree. In the other matter, the court will accept the defendant's plea to count 2. Count 1 is dismissed.
Okay.
Defendant is referred to probation for pre-sentence investigation and recommendation. Sentencing in this matter will be January 14th, 2025, 26, 9 a.m. Bond will continue.
Thank you.
Thank you, Your Honor.
Thank you. Yeah, thank you. Court does call the case People versus April Fleming.
Ashley Felton, people. Good morning, Assistant Public Defender Warren. Let me just state your name for the record.
Sorry.
State your name.
April Joy Fleming.
I am asking for hopefully one last adjournment. We've been adjourning for medical records. We did get some medical records, are waiting for records from Trinity Health. Hopefully I can get that mitigation over to the people and the company.
Ms. Fleming,
Yes,
were you huffing on Zoom?
I'm sorry.
Were you huffing?
No, I was not.
Are you sure?
Yes,
So if it was reported to me by two people that you were, they wouldn't be telling the truth?
I don't understand what you mean. Was I huffing when?
Today.
Today? No.
Where do you live?
I live at Chittister Place Apartments.
How long will it take you to get here?
I don't have a ride or anything. I don't know. To get there today?
Yeah, today. We saw you doing something you probably shouldn't have been doing.
What do you mean, sir?
Were you huffing?
Was I huffing just now? Like it's on camera? No.
Okay, today off camera, on camera, you been huffing?
No. No.
Not at all?
No.
So if you came down here and I sent you over for a test, everything's gonna come back negative?
Yes.
It will?
Yeah.
Okay, you're gonna need to find a ride. I'm gonna need you down here.
Okay, sir. I don't know how I could get there.
Ms. Fleming, I'm gonna give you a call, okay?
Okay.
Thank you.
Thank you.
And council approach first. Got it. Court does call the case People versus Jared Taylor.
Ashley Feltus for the people.
and Assistant Public Defender Natalie Pate, looking on behalf of Mr. Taylor, who stands to my right. Please state your record, sir.
Yes, my name is Jared Taylor. Thank you. All right. Jared Taylor? Yeah, I got you. Oh, okay. All right, I have two plea forms in front of me, both indicating that he's going to be pleading to retail fraud in the third degree. In the case ending in 0910, that's an added count 2, with count 1 being dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor. And that is our full understanding as well, Your Honor. Correct.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name, please.
Jared Taylor, Jared Lee Taylor. All right. Sir, it is this court's understanding that you are going to be pleading guilty to, or pleading no contest to 2 charges of retail fraud in the third degree. Is that correct?
That's correct, sir.
All right. Those are misdemeanors punishable by up to 93 days in jail, up to a $500 fine plus court costs. You understand that?
I do.
You understand that the fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You
Yes, sir.
understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, I do.
2 things about it I have to make sure that you understand. The first thing is I have to make sure that you understand. What is she doing? To make sure that you understand that it means that you're not further desirous or wanting to contest these charges. You understand that?
I do, sir.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
I do, sir.
All right, basis for the no contest, please.
Potential civil liability, Your Honor.
All right. So, sir, to the charge of retail fraud third degree as contained in the case ending in 0910, how do you plead?
Guilty. Oh, I'm sorry. No contest.
To that same charge as contained in the case ending in 1291, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
I do.
All right. You signed an advice of rights form. Is that correct?
I did.
Any question regarding any of those rights?
Not at this time.
All right. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, I do, sir.
You understand you're giving up your right to appeal of right.
I do, sir.
All right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you complete?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, I am.
Of your own free will?
Yes, along with my attorney's advice.
Pardon?
Yes, sir. I was just saying, along with my attorney's advice.
Okay, your attorney's advice, but the decision to plead is your decision.
It's my own,
Is that
yes.
correct?
Yes,
sir.
Yes, sir. Yes.
All right.
No, you just said advice. That's fine.
Court has been provided 2 police reports in the case ending in 0910, Pittsfield Township Police Report for their case number 24-13677. And in the other matter, it's Pittsfield Township Police Report for their case number ending in 259595. Any objection to the court having reviewed those reports?
No, Your Honor. No, Your Honor. Sorry.
Based upon a review of those reports, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, first of all, you would not be entitled to withdraw your pleas, and any sentence evaluation or recommendation, the court would no longer be bound by. You understand that, sir?
I understand. Thank you.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
All right. Court will accept the defendant's plea of no contest to count 2 in case ending in 910. Count 1 is dismissed. In the other matter, I will accept the defendant's plea of no contest to the single count. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in these matters will be January 14th or January 28th, 2025, 26. All right.
Thank you, sir.
Bond will continue. Thank you.
Thank you very much, Your Honor.
Court does call the case of the people versus Deanna Conrad.
Mr. Phelps with people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Conrad. Ms. Conrad, state your name for the record, please.
Deanna Conrad. All right. Court has a plea for, is that what we're doing?
That is correct, yes.
The defendant is going to be pleading to operating while intoxicated, to the charge of operating while intoxicated, that being an added count to the 93-day offense. Upon our successful plea to that charge, count one, the operating with a high BAC would be dismissed. That's the court's full understanding of the.
Yes, Your Honor.
That is our understanding as well, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the true self you got?
I do.
State your name, please.
Deanna. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail, a $500 fine plus court cost. Court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle mobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
I do.
All right. Still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind?
I understand.
All right. You signed an advice of rights form, is that correct?
I did.
Any question regarding any of those rights?
No.
You'll see a copy of one on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of them.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
I am.
of your own free will
Sir.
and because you believe that you are indeed guilty?
I am. Yes, sir.
All right. On the date of July 2nd, 2018, at the location of I-94 near Platte Road in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, you consumed intoxicating liquor.
I did.
Do you recall what you had and how much?
Being a brandy drinker, I'm sure it was brandy. I
All right.
do not remember how much.
Were you stopped by the police?
No, I was not.
All right. Was there an accident?
I was.
What happened?
I veered off of the I-94 and off of the road, and I hit a tree. What is it? The embankment. I hit a tree.
Did the police and ambulance arrive?
Yes, sir, they did.
And were you taken to the hospital?
Yes.
All right. And was there a blood draw, ma'am?
I'm pretty, yes, yes.
And if I told you that the results of that blood draw were 0.255, would you have any reason to dispute those results?
I would not.
Counsel stipulate to those as a result.
Yes, sir.
Yes,
All right. And you don't have any reason to dispute those test results? Is that correct?
I don't.
Pardon?
I don't.
All right. Ma'am, if I accept your plea, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rule, the court would you would not be allowed to withdraw your plea, and the court would no longer be bound by any sentence recommendation or evaluation. You understand that?
I do.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court law?
Before satisfied.
Satisfied, Judge.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. A pre-sentence investigation, well, defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
January 14th.
January 14th, 2025, 26, 9 a.m.
And Your Honor, I did have a request regarding bond and potentially the sentencing date. The court probably knew that was coming. So we are requesting a personal bond. Ms. Conrad, I've been messing up everyone's pronouns today. I'm sorry. Ms. Conrad has been in custody for 14 days as of today. As the court knows, Ms. Conrad has taken responsibility from this incident that was almost 7.5 years ago. Her prior is from 15 years ago. I had a chance to speak with Ms. Conrad this week about, what happened in her life that kind of made these incidents occur. She stated both actually arose the same nights that she lost her parents. Her father passed 15 years ago, and her mother passed 7.5 years ago, the day that this incident occurred. Since this incident, she has not had any other interaction with the criminal justice system. Again, she's taken responsibility for her actions on that day. She did plead to the lower charge. She's very eager to get out of custody and get back to work. She's currently on a leave of absence, and that leave of absence expires on the 19th. She's been at her job for about 3 years. She works a good job, and is concerned about that job, losing her income, losing her health insurance, things like that. I don't believe Ms. Conrad's a flight risk. She did come to court on the 3rd.
I'm not so much worried about her being a flight risk. I'm worried about her drinking.
I can guarantee you it won't happen soon.
So you already did that once and that didn't work, right?
I will say too, Ms. Conrad's been in custody. She's been out of work. I did ask if there's any bonds she could post. She believes she could post about $250 to demonstrate to the court that she will comply with any conditions. I will also say she did complete an assessment that was used in negotiations with Von Schwartz. That assessment was provided to Ms. Plura, I believe, when it was done a few weeks ago. I'd asked the court if the court is intending to keep her in custody, set sentencing for the 22nd. I know January 14th is quite a ways away. The holidays are coming up. So that would be my secondary request is do the sentencing as quickly as possible. I know that's hard for everyone involved, but the assessment has been done.
Miss Blondie.
Your Honor, the concern of the people is the concern of the court. I think we had 3 confirmed drinking events while the defendant was on a scram tether. I know that was a couple months ago, and the people have recognized the age of this offense and her lack of contact with the criminal justice system since it, and with the plea offer that was made and accepted. However, I would feel much more comfortable letting Ms. Plura have the interaction with the defendant, making the decision and advising the court about whether or not she thinks she can be safe in the community. We do understand the holidays are coming up. I think this court is well aware that could be a very triggering time for people who struggle with alcohol. If this was a case that had happened in 2018 and we had no bond violations and nothing else along the way, I would most likely have a very different position. But I'm concerned that this is an ongoing problem for the defendant, and I'm worried about the safety of the community.
Anything else?
Nothing else from me, Ms. Conrad. Did you want to add anything to what I said?
All I can do is plead with you. If I lose my job, I will lose my health insurance and possibly my home. At my age, it'll be hard for me to get health insurance pre-existing because, Your Honor, I will not consume any alcohol. I will not. I don't know what else to say. I can more than promise, I'll guarantee it. I will not consume any alcohol if you allow me to go and salvage my job.
Okay, here's what I'm gonna do. And I'll be honest with you, ma'am, I wish I could just sort of take what you're telling me on faith. It's a bit hard to do given where we've been in this case, right? I mean, here's the cold-hearted reality that almost 7 years ago or whenever this occurred, lived through that.
I'm sorry.
Lived through that. I mean, it's in a sense a miracle that we're even talking to you today.
That could never happen again, sir.
Here's the problem. You can't, and I understand you're giving me the guarantee. I understand all of that. And I would love to just take it on face value that that's what's going to happen. But you get here 7.5 years later and you can't, and you get put on a scram and you mess that up. And I think the prosecutor's correct. What really worries me about sometimes releasing people at this time of year, not only is this time of year triggering, but there's a lot of things around that could cause you just to slip up again. All right. And you can, in your heart, believe that won't happen. The problem is, I don't know that you can really say that with any surety. I don't doubt that you'll give it your best efforts because I don't think you like where you are right now. You've got a problem, and I say a problem, and that is that it's something you have to deal with. We'll set a sentencing for the 14th, January 2026, 9 a.m. If Ms. Polera and Ann, if we can fashion some type of release since her assessment is already done. I'd like a recommendation from Ms. Polera on her, and then I'll make a decision. But at this point, her bond would continue as is. But I'm going to take a look at the documentation from the assessment, have my probation officer look at it, and then make a determination if we can release her in some fashion.
I'll get in touch with Ms. Pilar today, Your Honor.
All right.
No, the omnipresent Ms. Pilar.
I know, it's scary. All right. Okay, so that's the way we'll do it. Thank you. Court does call the case of People versus Trayvon G.
The people.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. G, who is here on Zoom. Sir, can you please unmute and state your name for the court?
Yes, Trayvon G.
All right, what are we doing?
Thank you, Your Honor. Your Honor should be in receipt of a plea form as well as
I
plea
am.
report.
All right, the plea form indicates that the defendant will be pleading no contest to the charge of embezzlement by an agent or trustee less than 293-day offense, which is as charged. That's the court's full understanding. Well, there's also that the prosecutor will recommend prosecutors deferred sentencing. That's the court's full understanding.
Yes, Your Honor.
That is our complete understanding, Your Honor, as charged
Mr.
under the.
G, please raise your right hand. Do you solemnly swear?
When I got my shepherds, they're going to come take the cars off the roads and bring them down to Enterprise for us. So all of our teams can just hit our pump.
Hello?
Hello?
Yeah.
What? I'm not going to try to talk.
No, I can't barely hear you. It's going in and out the signal.
Yeah, but what is that in the background?
Oh, I'm at work. I turned that down. It was my work radio for my job.
All right, he has been sworn. Sir, it's this court's understanding that you are going to be pleading no contest to the charge of embezzlement by an agent or trustee.
Yes, Your Honor.
That's a misdemeanor punishable by up to 93 days in jail, a $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000 or greater than $500, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor. I talked with my public offender. She explained it to me.
Okay. 2 things you have to know about it. It first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, I did.
Any questions regarding any of those rights?
No, Your Honor.
You understand that you're giving up those rights, particularly the rights that are contained in paragraph 5, your trial rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And because and of your own free will. The court has been handed and has reviewed Pittsfield Township Department of Public Safety report for their case number 2413164. Any objection to the court having reviewed that report?
No, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No.
And have I complied with the court rule?
People are satisfied. Yes.
Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for pre-sentence investigation and report and determination of prosecutors deferred. Sentencing in this matter will be
January 28th.
January 28, 2026, 12 noon. All right?
Yes, sir.
Thank you. And hang on the line. We're going to put you into a breakout room with our probation intake so we can get the process started. Okay, sir?
Okay. Yes, sir.
Thank you.
Thanks,
You're
Mr.
welcome.
G.
All right. You too.
Court
Mr.
calls
Knapp.
case People versus Joseph Griffin.
Conrad Solar on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Griffin. Griffin, state your name for the record, please.
Joseph Bertram Griffin, Your Honor.
Your Honor, Mr. Griffin is another individual that we're waiting on a release to treatment on. He has a couple cases up in circuit court that are being worked out, and a couple holds in Canton that we're working on as well. So I just asked for an adjournment.
Adjourn the matter out when I go to the 21st, just January 21st, 2026, 9 a.m. We need to see him before that.
Thank you. I do think there's a release on this, on all of his
I think there's a
files.
release on that case.
Yeah.
All right.
Thank you, Your Honor.
Thank you, sir. Court, good, does call the case, People versus Keontae Wright.
That's helpful for the people.
Keontae Wright.
Assistant Public Defender Natalie Pate with behalf of Miss Wright, who is approaching.
Oh, there. Your name?
Keontae Wright. Thank you, Your Honor. I'm respectfully requesting an adjournment. I have been able to discuss this case with Miss Wright, and I was able to provide her with a discovery packet today. We're asking for some more time to review some of the media discovery together.
January 7th, 2026, 9 a.m. bond continued.
Thank you, Your Honor.
Court calls case versus Trevor Howard.
Ashley Feltus for the people.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Howard. Mr. Howard, state your name for the record.
Trevor Scott Howard.
I apologize, Your Honor. I thought this case was set for January 7th when I checked the ROA yesterday. I did not speak with Mr. Howard. It came up on my case management system. He wasn't on the initial docket sent out by the court, so I checked the ROA. So I apologize to Mr. Howard.
It looks like Mr. Howard has a felony that's up tomorrow as well, so maybe that has something to do with it.
Well, he is a PCC tomorrow, or is it
Yes.
circuit court?
BCC.
Well, what I can do is this, Ms. Fairney. He's being held on that other.
On the felony case.
It does look like he's being held on that one. The notes in it from Ms. Senda from October of this year indicate he failed to appear for a probable cause conference and that the tether had been cut off. So I'm guessing he has either a very high bond or no bond in that case.
His bond has been denied in that case because it has in this case also.
Okay.
Because, I'm sure because of the tether being cut.
Well, Your Honor, I just wanted to make sure if there's anything that I need to say today that could get that done. But given that he's up tomorrow, I will speak to the attorney that's assigned to the PCC. If there's anything that we need to get to the court regarding this, I will do work on that. And again, I apologize to Mr. Howard.
Sure he appreciates that, but maybe he should apologize to all the people that were waiting for him since October. January 7th, 2026, 9 a.m. We'll continue as denied. Court calls case People versus Sincere Godwin.
Good afternoon, Assistant Public Defender on behalf of Mr. Godwin. Mr. Godwin, state your name for the record, please.
Sincere Godwin.
Okay, there you go. All right.
Your Honor, I'm asking for a brief adjournment. Mr. Godwin and I were playing a little bit of phone tag. So I just wanted to be able to touch base with you.
Adjourn this January 7th, 2026, 9 a.m. bond continued. Thank you. Court does call the case of the People versus Kawandake Thomas.
Ashley Feltus for the people.
Public Defender Natalie Pate with and on behalf of Ms. Thomas, who stands to my right. Please state your name for the record, ma'am.
Kiwanis Cynthia Rose Thomas.
Thank you.
Thank you, Your Honor. I have two requests. One would be for an adjournment. We have been able to go over the police report in this case, but we need some more time to go over the media. And my second request is I do believe that Ms. Thomas has released to treatments on her felony file. So I'm just asking if the court would allow a release to inpatient treatment on this case.
No position, Your Honor.
All right. Yes, with a GPS tether. So I will sign that order if it's presented.
Absolutely,
Adjourn
Your
this
Honor.
matter out to January 7th, 2026, 9 a.m.
Thank you very much, Your Honor.
Thank you.
Court does call the case People versus Tony Gomez.
Ashley Feltus for the people.
Lauren Kearney on behalf of Mr. Gomez. Mr. Gomez, state your name for the record, please.
I haven't checked in. Wow.
We're so close to resolving this case, Judge.
Yeah.
Yeah. Sorry, my emotions got the better of me. I just really want.
Oh, it could have been worse.
I just really want Mr. Gomez to make it into Veterans Treatment Court. So I guess I'd ask for an adjournment for the record.
Bench warrant,
Oh, he's not here. He's not here.
$7,500. I'll give a 10% privilege. That warrant will issue immediately. I know, because we're all set to do it. Court does call the case, People versus Matthew Wallace.
Conrad Sol on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Wallace. Mr. Wallace, state your name for the record, please.
Matthew Wallace.
Your Honor, we're requesting adjournments in all three cases. We're working out a global resolution at circuit court. We think we're pretty close to that. So just requesting adjournment.
I don't mind giving the adjournment for that purpose. When's his next? I mean, when do you think that'll be resolved in circuit? So
bit of a complicating factor is he was arraigned on a new case yesterday. That's kind of a late add-on to that needs to be worked out. He's scheduled to be seen by Judge Conlon this afternoon. So I assume that's going to be adjourned out a couple of weeks.
it's a new case he was arraigned on. Did that get set for, is that a felony?
Yeah.
It gets set for a PC.
Yes, I
When
believe.
is that one set?
24th. I want to say the 24th of December.
I'm sorry?
December 24th, I believe.
Or the
Or the 23rd.
Third? Did they say, okay, so they
Yeah,
said
23rd.
the 23rd.
Yeah.
Okay. All right, let's do this then.
Yeah.
I'll set this one then as close to that one as I can, and if they adjourn that other one out, we may time this up.
Turn in the information of county attorney and the county attorney submits them. I don't know how the clerk gets involved, if they're just strictly record keeping or if they sometimes enter them. That's why I'm asking the clerk who's.
My pleasure, Your Honor. Have a great day.
You do the same.
Will there be anything
Court
from the
calls-
Spanish interpreter, Your Honor?
Yes, we are all set. I'm sorry. Thank you, sir.
Okay, my pleasure, Your Honor. Have a great day.
You do the same.
Thank you.
Court calls the case, People versus James Hagan.
Ashley Feltus for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Hagan, who may be present on Zoom.
You have him or no?
No, sir.
Not here. When?
He's not currently.
Are you sure he was here early?
Your Honor, we were going to request an adjournment anyway, Your Honor, if the court would be so inclined.
He's not in the meeting.
I mean. Mr. Hagan?
Yes, I'm here.
He's not lighting file.
Sir, can you please state your full name for the court?
James Hagan.
Thank you, Your Honor. I'm requesting an adjournment. I believe this case might be headed to final settlement conference eventually, but I need to have another conversation with Mr. Hagan first.
I'll adjourn it January 21st, 2025, 26, 9 a.m. Bond continued.
I apologize, or that's 21st. Okay, thank you. Thank you, Mr. Hagan.
Court calls the case, People versus Maya Hines.
Ashley Feltus for the people.
Good. Ms. Hines. Ms. Hines, state your name for the record if you can. I will say I spoke with Ms. Hines this morning. She's also very ill. She said she can barely speak. So I said I would
okay
speaking for her. Because of that, we're deciding for adjournment. We do think we're close to a resolution. Ms. Hines is just really ill.
I'll adjourn it to January 21st, 2026, 9 a.m. All right. Ms. Hines, feel better. Bond continued. Court calls case of the people versus Devontae Johnson.
Felt this for the people.
Yes.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Johnson, who appears on Zoom. Sir, can you please state your full name for the court?
Devontae Johnson.
Your Honor should be in receipt of.
I am. I have a plea form that indicates defendant is going to plead to retail fraud, guilty to retail fraud, 3rd degree, 93-day misdemeanor. On a successful plea to that charge, count 1, the retail fraud 2nd degree would be dismissed. The defendant in this case is also agreeing to make restitution in the amount of $732.82 to Dick's Sporting Goods jointly and severally with the co-defendant. That's the court's full understanding of the issue.
That is correct, Your Honor.
That is correct in our understanding as well, Your Honor.
Mr. Johnson, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name for the record again.
Devontae Johnson.
You understand that by pleading, you can put your hand out. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud in the 3rd degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that could become the maximum fine. You understand that, sir?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form or had it signed on your behalf?
Yes, sir.
Any questions regarding any of those rights?
Yes, sir.
Please look at paragraph 5 on that form if you have a copy. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as other rights contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Yes, sir.
Okay, were you on probation or parole in March of this year?
No, sir.
Has anybody promised you anything other than what's stated here today to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
March 3rd, 2025, at the location of Dick's Sporting Goods on Laurel Road, I do believe, in Pittsfield Township, Washtenaw County, state of Michigan. What'd you do that makes you think that you're guilty of this offense?
I went in the store and took merchandise that didn't belong to me.
And you tried to walk out of the store without paying for it?
Yes, sir.
The store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take this property, did you?
No, sir.
And this property that you took was property that was offered for sale by Dick's Sporting Goods?
Yes, sir.
Sir, if I accept your plea and you commit misconduct between the time I accept your plea and the time of sentencing, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court order?
Or satisfied.
Yes.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be January 28th, 2026 at 12 noon. All right, bond will continue. Sir, wait on the line. I'm going to put you into a breakout room with my probation department so we can get the process started.
Okay, thank you.
Thank you.
Thanks, Mr. Johnson.
Court calls case People versus Mohammed Kahala.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Kahala, who should be present on Zoom.
There it is. Got it.
Sir, can you
how's it
state your
going?
name?
Mohammed
State your
Kahala.
name. Thank you.
Thank you, Your Honor. I have been able to review all the discovery with my client, and at this time, we're asking to set the case for final settlement conference.
jury final settlement conference will be set for February 6, 2026 at 9 a.m. Jury selection, if necessary, February 9, 2026, 8:30. Both of those proceedings are in-person proceedings.
Okay.
All right, thank you. Bond continued.
Thank you, Your Honor. Thanks, Mr. Hollow.
Court calls case People versus Lerone Kelsey.
Bye-bye.
Ashley Feltus for the people. Good afternoon, this is Public Federal Law Attorney.
Here, Your Honor.
State your name, sir.
Lerone Kelsey.
All right, I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of operating while visibly impaired. That's count 3, the 93-day offense. Upon a successful plea to that charge, count 1, operating while intoxicated, and count 2, operating without security, would be dismissed. There is an agreement that the case will be transferred to 36 District Court or District Court Sobriety Court.
Yes, Your Honor.
That's the court's full understanding.
Ours as well, Your Honor.
All right. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name for the record.
Lerone Kelsey.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
All right. And understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You had signed or had cause signed a advice of rights on your behalf. Is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Looking at paragraph 5, those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as other rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes. Probation.
Were you on probation at the time of this offense in February?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes.
February 7th, 2025, at the location of US 23 near I-94 in Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
I had wine and I probably had like 4 glasses before I went to work that night.
All right. Were you stopped by the police or was there an accident?
I was stopped by the police. There was no accident.
Why did they stop you?
I'm sorry?
Why did they stop you?
I just don't remember.
Driving.
Pardon?
Driving, Your Honor.
Driving.
Yeah.
Erratic driving.
Yes.
All right. You're not disputing the right of the police to stop you in this case, are you?
No.
All right. After they stopped you, were you ultimately arrested?
Yes.
All right, were you taken to the hospital for a blood draw?
Yes.
Do you recall what the results of that blood draw were?
I believe it was 1.17.
Maybe 138 or 137, I'm sorry.
Yes.
All right. And Ms. Farroney, you stipulate to that.
We do, Your Honor.
All right. You don't have any reason to dispute those blood test results, do you, sir?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. Sir, if I accept your plea between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Yes. Counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rule?
People are satisfied. Satisfied, Judge.
Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed.
And Your Honor, Mr. Kelsey did do an assessment with 36 District Court. I will communicate with Ms. Falara to see if that's satisfactory, if we can use that assessment that he already did, since he's already pled there and it's on probationary.
All right, what I will do is I still will, for my purposes, refer him to Von Swartz for an alcohol screening and assessment. And the victim's impact panel sentencing in this case will be.
January 28th at noon.
We'll probably get him done. Well, we'll do it the 28th. If Teresa or Ms. Polero moves it up, that's fine with the court. January 28th, 2026, 12 noon. All right. Sir, I want you to stay on the line. Yeah. Your bond will continue. We're going to put you into a breakout room with my probation department to get this matter moving forward, okay?
Okay. So, Your Honor,
Thank
while
you.
I have probation. Okay.
Okay. Will you what?
Well, I have probation with you guys, court.
I ain't gonna say this out loud. Well, likely not. Likely your case is going to get transferred to 36 sobriety court.
Okay.
All right. Thank you.
Yes. Thank you.
Court calls the case, People versus Austin Knox. Arraignment without counsel.
Yes.
Your name, sir?
Austin James Knox.
All right, Mr. Knox, you are before the court on a 4-count complaint, misdemeanor complaint. You understand that, sir?
Yes.
All right. All right. The complaint in this case alleges that on or about February 24th, 2025, the location, Pittsfield Township, I don't have the specificity, actually, at the location of 3688 Colt Drive in Pittsfield Township, Washtenaw County, state of Michigan. Count 1 alleges that on that date, that you did take, hold, or conceal or destroy mail addressed to another person, that being Chong Chow. You understand the nature of that charge, sir?
Yes.
That's a misdemeanor punishable by up to 1 year incarceration, a $500 fine plus court costs. You understand the maximum penalty. Count 2 alleges the same offense with regard to mail addressed to Paula Davis. Do you understand that charge, sir?
Yes.
That's also a misdemeanor as indicated, punishable by up to 1 year incarceration, a $500 fine plus court cost. Count 3 alleges that same offense with mail addressed to a person by the name of Rosa Gomez. Do you understand that charge, sir?
Yes.
That's a misdemeanor, 1 year, $500 fine plus court cost. Count 4 alleges the same offense regarding mail of an Alexandria Pa Kelly. You understand that charge, sir?
Yes.
Misdemeanor punishable by up to 1 year, $500 fine plus court costs. You understand that, sir?
Yes.
First question I have for you is, do you want to be represented by an attorney?
Yes.
This is a public defender case.
Public defender Norman Tate, sir, with and on behalf of Mr. Knox, we would waive any further reading of the complaint. My client stands mute, and we would ask for an adjourned pretrial date as well as a PR bond, please, Your Honor.
Defendant having waived for reading, standing mute, court will enter a not guilty plea as to all charges. I will adjourn this matter to January 7th, 2026, 9 a.m. The bond in this case, I will set his bond at a $10,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of any weapons or illegal drugs. You understand that, sir? Yes. I will also indicate there's to be no possession of any consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes.
I'm further going to order no contact with any of the named victims in this case. You understand that, sir?
Yes, Your Honor.
Is there any reason you need to go anywhere near or be near Colt Drive in Pittsfield Township?
I don't even remember where that is. So no.
All right, I'm going to indicate defendant not to go to Colt Drive in Pittsfield Township. Sir, if I sent you over for a drug test today, you going to pass?
I have my medical marijuana card. THC is the only thing I will not pass for.
That's the only thing in your system?
Yep. The only thing in my system, Your Honor.
I'm going to order that the defendant is to report to community corrections for weekly drug testing. He's to go take a test today.
Does it cost anything?
Yeah, you'll have to notify.
Understood. So before you leave these premises, you need to go over to community corrections and take a drug test. You understand that, sir?
Yes.
All right. Thank you. Court calls the case of the People versus Lindsay Kohler.
Question called this for the people. And this is a public defender now taken by behalf of Ms. Kohler.
Hi there. Thank you, Judge.
Ma'am, can you please state your name for the record?
Lindsay Marie Kohler.
Hey, you're going to need to speak up. You're
Lindsay
sort of
Kohler?
faint, something. Thank you. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading guilty to the charge of operating while visibly impaired, the 93-day misdemeanor. Upon her successful plea to that count 2, count 1 would be dismissed. That's the court's full understanding of the plea agreement.
Yes, Your Honor.
That is correct, Your Honor.
Ma'am, please raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I swear.
State your name for the record again, please.
Lindsay Kohler.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, a $300 fine plus court costs. The court could also order that community service or any rehabilitation the court deems necessary, could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Understood.
All right. Do you still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form or had one caused to be signed on your behalf?
Please ask that again.
Pardon?
What was that, please?
You either signed an advice of rights form or caused your attorney to sign one on your behalf. Is that correct?
Yes.
All right. Do you have any questions regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form if you have it. Those are your rights
Yes.
which are part of a trial. You understand that you're waiving or giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No,
Has anybody promised you anything other than what's been stated here today to get you to plead?
no,
Has anybody threatened you or coerced you?
no,
You're doing this voluntarily and of your own free will?
correct.
And also because you believe that you're guilty of this offense?
Correct.
August 27, 2024, at the location of Merritt Road near Carpenter Road, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Correct.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Correct.
What did you have and how much?
A few drinks like IPA or stouts that evening.
All right, were you stopped by the police or was there an accident?
Neither. I ran out of gas and I showed back up to my car.
All right. Had you also smoked marijuana that night or taken THC in some fashion?
Oh, wait. Yes, always. Yeah, which I also have I'm getting my card as well.
The police arrived at the scene.
Yes, I was away from my van and I showed back up to it to maybe go get more gas. I was having help and there was just a bunch of police around the van.
Were you ultimately arrested?
Yes,
You're not disputing the right of the police to arrest you in this instance, are you?
I'm not trying to, no.
Pardon?
No,
All right. Were you taken to the police station or taken to the hospital
both
for a breath or blood test?
the hospital then the police.
All right. What were the results? You had a blood test at the hospital. What were the results of your blood test?
If I asked, it was like 0.16.
Yes, Your Honor, that defense would stipulate to that.
All right. Do you have any reason to dispute those blood test results?
No,
Yeah. Did your blood test results also show the presence of THC and or its derivative?
I didn't ask those questions, sir. I don't know. I was focused on alcohol.
Defense would stipulate that there was the THC in the system, Your Honor, the blood test result.
10 nanograms of active delta-9, Your Honor.
Thank you. Ma'am, taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol and maybe your ingestion of marijuana?
Yes,
I didn't hear you.
yes,
All right. Ma'am, if I accept your plea, do I have to advise you if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, that you would not be permitted to withdraw your plea, and any sentence recommendation or evaluation, the court would no longer be bound by. You understand that?
understood.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court?
People are satisfied.
Yes. Yes. Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed.
Thank you, sir.
Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this case will be January 28, 2026, 12 noon. All right, thank you. Ma'am, you'll need to wait on the line. I'm going to put you into a breakout room with my probation department so we can get the sentencing process started. Thank you.
Understood. Thank you.
Court calls the case, People versus Rodney Allen. Or I'm sorry, Rodney Lilly.
National Focus for People.
And Assistant Public Defender Natalie Table on behalf of Mr. Lilly, who's present on Zoom. Please, sir, can you please unmute and state your name for the court?
Go ahead. Rodney Lilly.
Got it. I have a plea form. Is that what we're doing?
Yes, Your Honor.
Your Honor, is Your Honor also in receipt of a police report?
Is this the one that came in late?
Yes,
Yes.
it was, Your Honor. Good evening. I do apologize.
I know. I do. This court's understanding is that the defendant will be pleading, I'm presuming, no contest
Yes, Your Honor.
to the charge of false or failure to report an accident, a 90-day offense. Upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
That is correct, Your Honor.
Sir, please.
We'll note for the record, I'm sorry, Your Honor, I don't mean to interrupt, but that there's likely to be a restitution request, so we are going to object to immediate sentencing.
Understood.
What?
Did they have, you had a question on that?
No, sorry.
Well, who are you?
My wife's sitting beside me, sorry.
All right. Sir,
Yes, sir.
you've heard the agreement?
Yes, sir.
All right, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. I
State
did.
your name again for the record, please.
Rodney Lilly.
All right, you can put your hand down. Sir, it's this court's understanding that you're going to be pleading no contest to the charge of failure to report an accident. That is a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
Two things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Basis of the no contest plea.
Potential civil liability.
Sir, to that charge, how do you plead?
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form or had one caused or had
Yeah.
someone or caused one to be signed on your behalf, sir?
Yes, sir.
You have any question regarding any of those rights?
No, sir.
Noting paragraph 5, you understand that those are your trial rights and that you're giving up those rights as well as all the rights that are contained on that form.
Yes, sir.
You understand you're giving up your right to appeal upright.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will.
Yes, sir.
Court has been provided and has been able to review Michigan Department of State Police report for their incident number 619825. Any objection to court having reviewed that report?
No, Your Honor.
No.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
I am not, Your Honor.
No.
And have I complied with the court?
The people are satisfied.
Yes.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Defendant is referred to probation for pre-sentence investigation and report and determination of any restitution. sentencing in this matter will be January 28th, 2026, 12 noon. Bond will continue. Mr. Lilly, I need you to wait online.
Yes, sir.
And I'm going to put you into a breakout room with my probation department. Understood?
Yes, sir.
Thank you. Court calls case, People versus Gregory Lockridge.
Mr. Phillips for the people.
I'm Lauren Kearney on behalf of Mr. Lockridge. Mr. Lockridge, state your name for the record, please.
She here.
Gregory Lockridge.
Thank you.
Hoping to get some documentation for my client over to the people.
During this matter to January 21st, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case, People versus Elizabeth Lohman.
For the people.
Oh, got it. Hello,
Hello,
what's your name?
Elizabeth Loman.
Sloman, you are here before the court